Hello again, everyone. Patty Movahill, back to talk about public meetings in Oregon, the legal requirements, and then we're going to finish up by talking about some best practices. The best practices are practices that Jamie and I have kind of developed and witnessed over the last several years. So let's start with the legal requirements because as a lawyer, that's what I probably care most about. So let's start with identifying what constitutes a public meeting. As a city councilor or mayor or city manager who staffs a city council, the public meeting is probably where you're the most visual to the public. It's what we typically equate with city councils, right? You're in some type of chamber, you're having an official meeting, and it's all very official. But in terms of when the Oregon Public Meeting Law applies, it's only going to apply to those meetings that meet the definition of a public meeting. So what is a public meeting? It's the convening of any governing body for which a quorum is required to make or deliberate towards a decision or to gather information. And the gather information is underlined under your slide because you're not going to see that in the statute if you were somebody who went to look at the actual statute. But gathering information has been interpreted by the Oregon Attorney General as constituting a public meeting in and of itself. So when the league gives you the definition of what constitutes a public meeting, we include that section as well. So essentially, you got to look, what's my governing body? Well, for the most part, I'm going to assume you're all with the city. So the governing body is predominantly your city council. And if you need a quorum to gather, which you do under most of your charters, to make a decision, to gather information, to deliberate, then that is, in fact, a meeting that's subject to the Oregon Public Meetings Law. On the right side, you're going to see a couple key things that are relevant to having a lawful public meeting. First of all, there are no secret ballots allowed. So at some point in your career, you're going to be asked to make a really difficult decision. And you're going to have to make those decisions in public. One of the trickiest ones, I think, for public officials is sometimes an elected official resigns early from their position. So let's say you have Councilor Smith, and Councilor Smith is going to relocate to Washington, so they have to resign their position on your city council. And under the charter, the city council gets to appoint Councilor Smith's replacement. Well, let's say you have 3 people interested in the job, and there are 3 people in the community that you know, that you like, that you respect, and you've got to decide which one of those 3 you're going to pick. And a lot of times people will call the league and say, hey, can we make that decision secretly? I don't really want to have to make it in public. And the answer is no. Your decisions all have to be made publicly. There are no secret ballots allowed when you're in a public meeting. The other part you need to know is that the governing body is not just restricted to the city council. So the Public Meetings Law applies to other bodies or committees that make recommendations or make decisions. So your planning commission, your budget committee, those are all committees that are going to be subject to the Public Meetings Law. Let's say, for example, you have an issue with homelessness in your community, and you decide you're going to create a homeless task force committee. And that committee is in charge of studying the issue, coming up with solutions, and making recommendations to the city council on how to address the issue. Because your homelessness task force is going to be making recommendations to the city council, under the Public Meetings Law, it becomes its own separate governing body that's also subject to the Public Meetings Law. Your public meetings are going to apply whether you're holding them in person or you're holding them electronically. My guess is if you've been on a council this year, you've had a lot of electronic public meetings. Zoom, Microsoft Teams, GoToMeetings, they've become our new best friends. And even though you may be sitting in a meeting electronically or on the telephone, it's still going to have the same requirements as an in-person public meeting when we talk about notice and minutes, and we'll get to those in a minute. But it doesn't matter your forum. If you have the governing body with a quorum convening to deliberate, make a decision, or gather information, it's going to be considered a public meeting. And the last thing to note is quorum is going to depend on the city itself. Quorum is usually identified in your city charter, but for simplicity's sake, it's usually one more than half. So if you have a 5-member city council, quorum's usually 3. 7-member city council, quorum's 4. 9-member city council, quorum's 5. Double check your charter because it could be different, but that's generally a good rule of thumb. So what are the legal requirements to have a public meeting? The first is notice. And when we talk about notice, notice is what we call a public notice. You may hear that. And the notice is generally going to do the who, what, where, when, and why. So who's meeting? Which governing body? Is it the council, planning committee, budget committee? Who's meeting? What? What are you meeting about? Are you trying to adopt the budget? When are you meeting? So we're going to meet on March 12th, 2021 at 3:30 p.m. Where are you meeting? We're meeting in city council chambers. We're meeting over the telephone, and here's the phone number to participate if you want. The why is generally accomplished by putting in the agenda. So a lot of times with a public meeting notice, you'll see an abbreviated agenda attached, and you can see that on the right side of the slide in front of you. Under state law, and I'm going to make it clear, state law, notice must be posted at least 24 hours in advance of a meeting, unless you have an emergency. So the reason I want to highlight state law is because this is the minimum you have to comply with under the Oregon Public Meetings Law. But you want to check with your city recorder and city manager because your city charter or some of your local ordinances could have different requirements. So, for example, up until very recently, the league's board of directors was required to give 5 days notice before the board met. So even though we only had to do 24 hours under state law, our local governing documents actually required us to do 5 days. So under state law, the minimum is 24 hours unless you have an emergency. Now, I pessimistically believe that emergency is one of the most overused and misunderstood words in the English language. So under state law, an emergency means you literally have no other choice but to hold the meeting with less than 24 hours notice. It's not an acceptable reason that what's more convenient for me, or there's about to be a really nasty press release tomorrow and I want to get in front of it. It literally has to be, we must meet with less than 24 hours notice. So let's say, for example, it's most budgets in Oregon, your budgets are usually run July 1 to June 30th. So by June 29th, most cities have probably exhausted most of their revenue that was in their budget for that fiscal year. And let's say the main water line happens to break and explode. You're losing thousands of gallons of water every minute. It's flooding your entire downtown. There's going to be massive property damage, but you simply don't have the funds to bring in the extra contractors to fix the work until July 1st when the new budget kicks in. I would suggest it would probably be okay to have an emergency meeting to do an emergency appropriation so you could hire the necessary contractors to get the water main fixed and stop the damage. That would probably constitute an emergency. Your public meeting has to be held typically within your city's own jurisdiction. So if you are, for example, the city of Madras, your city council meetings should be happening in Madras. They should not be happening in Redmond or Bend. The slight caveat to this is, let's say that Madras and Redmond want to work together on a project. So you're putting together some type of joint initiative as city councils. And we're past COVID-19, and so the Madras City Council and the Redmond City Council want to meet together in person. You obviously can't do that because you have two separate jurisdictions. What the statute allows is for you to meet in another person's jurisdiction in that instance. But normally, when you are only doing your own city's business, you need to be holding those meetings inside your city's jurisdictional limits. Your meetings have to be held at an accessible location. So I think a lot of times when we think about accessibility in terms of locations, we think about being accessible for people who might be utilizing a wheelchair or other assistance for mobility issues, and that's certainly true. But it's also true that you may need to make reasonable accommodations for other members of your community who, say, have hearing challenges or are visually impaired. So if you think about it, you could have residents who can't hear what the council is saying, but those residents still need to be allowed to participate in the process involved in how they're governed. Same thing for those who are visually impaired. So what you have to do is make a notation on your public notice that says that you will make reasonable accommodations. and that if somebody needs an accommodation, they should contact a specific city staff person and give them our name. Again, if you look at this sample league notice that's on your slide, you'll see some of the language that we use to make sure we hit that accommodation. The other thing that you have to worry about in terms of location is you can't hold your meetings in a location that discriminates against somebody in a protected class. A protected class is gender, race, ethnicity, religion. So let's take gender, for example. Let's say the city of Smithville, which doesn't exist, but it's pretend, the city of Smithville wants to hold its city council meetings in a building that prohibits women from entering inside of it. That would be impermissible under the public meetings law because why? We can't discriminate against people because of their gender, and you have female constituents who need to be able to come in and speak with you as elected officials. For each public meeting that you have, you're going to have to ensure that minutes are taken. And there's some specific requirements for the minutes. Now, for the most part, if you're an elected official, this onerous on taking minutes isn't you. It's probably mostly city recorders who have to worry about it, but you should still know because sometimes we will get calls from elected officials. Your minutes don't have to be written minutes. So they can be audio, they can be digital. There just has to be something that reflects what transpired at the meeting. What they do require, though, is we have to know who's made a motion. So I actually need to know which elected official made the motion, who made the second, and how each elected official voted. So it's not enough. So for example, if you've got 5 members and the vote is 4-1, when you say 4 yay, you need to identify the 4 elected officials who said yay, and then the person who said nay is also going to have to be identified. You also have to have information about ordinances or resolutions, each official action that's taken, and if the council had written materials that they considered during the course of the council meeting, those have to be referenced in the minutes as well. The substance of your discussion needs to be included, but it's important to note that minutes are not transcripts. Whether or not you choose to do, minutes are traditionally a summary of what occurred, whereas a transcript is a literal verbatim account of what happened. Patty Movahill, and then you say exactly what I said. Jamie Hafner, and then exactly what she said. That would be a transcript. Whether or not your city chooses to do a summary with minutes or a transcript is up to each city individually to decide. I would say normal and common, and I always recommended to my clients that we stuck with the summary and the minutes and we avoided doing a transcript unless we were legally required to by court order or some other provision. So serial meetings. If you are new to local government or you haven't attended one of the league's trainings in the last 3 years, serial meetings may be a new concept for you. So when we think about meetings normally, right, so we know that a quorum of the governing body can't meet unless we've posted a public notice, right, and we've invited the public to attend. And when we think about that, we think about us all being together at the same time, right? So I've got a quorum of my council, and we were all in the same meeting room together talking about things, or we were all on Zoom at the same time, all on the phone call at the same time. What a serial meeting is something different. It's not intuitive to what we think about meetings, but it's where we can get in trouble. So I'm going to try and explain this without actually having a visual example. So a serial meeting is when smaller groups of individual council members have a series of separate meetings that equals a quorum. So let's take a 9-person city council. So we know quorum is 5. And for simplicity, we're going to say the councilors are named A, B, C, D, and E. So A and B meet to discuss an ordinance about water rate increases on Monday. They meet at the local park, they have a conversation. A's in support of the water rates, B's really kind of iffy. And then B, 2 days later on Wednesday, is at the grocery store and runs in to C. And those two, in the course of their conversation, start talking about the water rates, what they each think about it, how they want to vote, where it's going to go. And then 2 days later on Friday, when C's emailing a brownie recipe to Counselor D, in the course of their email exchange, they start talking about the water rate increase and how they both think about it. And then the very next day, A and E run into each other at the park and they start talking about it. So 5 people never were together at the same time, but 5 people through a series of different meetings and different formats all discuss the water rate increase that's coming before the council. That's considered a serial meeting, and they are not permitted in Oregon. And the reason they're not permitted is because my guess is not a single one of those separate interactions or meetings was publicly noticed. The public wasn't invited to attend, they weren't allowed to listen to the discussions, and they weren't allowed to ask questions. So you were essentially doing the public business without the public being allowed to see you conduct that business. Now, in my opinion, serial meetings happen not because normally government officials are trying to hide what they're doing, but because it's normal. I ran into this person and this is what we have in common. Or I just want to get a feel because I don't really feel like I understand water rates and I'm a new counselor and the mayor just knows so much more about it and they're accidental, right? And so they just happen inadvertently and without malice. But you have to worry about those. So what we at the League always strive to tell people is you should err on the side of caution. And by that, if you want to discuss city business with fellow counselors, discuss it in a publicly noticed meeting. That's the safest way to go about ensuring you don't inadvertently create a public meetings violation. If you take a look at the statute that deals with public meetings, you are not going to see the word serial meetings anywhere, and you're not going to see it described in statute. And that's because it's not there. We are prohibited from having serial meetings because of a decision that was issued by the Oregon Supreme Court in the last 2 or 3 years. And the Supreme Court interpreted the language that is in our statute to inherently preclude serial meetings from happening. So if you're somebody, again, who likes to read statutes, you won't find this term in here, but if you're super interested in the case, I can certainly send it to you. So that's what you have to do for public meetings. There are opportunities for councils to meet in executive sessions or in closed door meetings. And what that essentially means is it's a meeting, or it can't even just be a part of a meeting, but it's a meeting where your governing body has closed the meeting to certain persons so that you can deliberate on certain matters that are permitted under state law. So what you've essentially said is the city council is going to meet behind closed doors, and we're not going to allow the public to attend the meeting. We might allow 1 or 2 people in, but we have a specific reason for doing so. So let's talk about why you would want to have an executive session and who you could or could not invite in. So I'm going to give you an example that's not on several slides later. One of the best examples is a few years ago, the Ninth Circuit Court of Appeals, that's a federal circuit court, and Oregon is one of the states that's subject to the Ninth Circuit's jurisdiction. So a couple years ago, the Ninth Circuit issued opinion in a case called Martin v. Boise. And what the Boise case did was it essentially said that we as cities and counties and special districts and states, we can't criminalize certain inherent acts of being homeless. So for example, what had happened was the city of Boise had an anti-camping ordinance, and as part of that camping ordinance, it prohibited people from sleeping or lying on public property. And it was enforced against several individuals who were experiencing homelessness. And as it worked its way up, eventually what the Ninth Circuit Court of Appeals said under the 8th Amendment to the U.S. Constitution, which prohibits cruel and unusual punishment, Boise's ordinance was inherently punishing people who experienced homelessness for something they couldn't control. And by that I mean, if I have nowhere to go, if I have no home, there is no place to go, if there is no available shelter bed to me, I am physically unable to not sleep. At some point, my body requires sleep. And if I have nowhere else to go, I have to sleep outside, and I will probably end up sleeping on public property. And so a lot of anti-camping ordinances in Oregon suddenly became subject to review. So let's say your city had an ordinance similar to it and you thought, oh my gosh, I feel like that decision may impact us and I want to have an executive session to discuss it with my attorney. You obviously want to have the executive session for your city council, but you probably want to invite your city attorney. You may also have a police chief who regularly has his department issuing citations for these camping ordinances. So you may want to invite your police chief. The point is the council decides who gets to come into the closed executive session. It's not just only the council. When you hold an executive session, you still have to post notice of it. So you still have to say, the city council meeting is going to be meeting an executive session on this date at this time. And you have to identify the specific statutory reason that allows you to have an executive session. We'll get into the specific reasons that are mostly applicable to cities here in a minute, but it's important to know that your notice that you post is going to need to reference the specific statutory provision that allows you to go into a closed-door session. The news media has a right to attend virtually every executive session. The main caveat would be is, let's say your city is in the middle of a litigation with the Oregonian, and you are having an executive session with your attorney to discuss that litigation. The Oregonian could be excluded from that executive session. Other news media would still be allowed to attend, but you could exclude the Oregonian from that. What you have to do when you go start an executive session, and we can give you a model script if you need it, is essentially say what can or cannot be discussed once the executive session is done. And what that does is it tells anybody who's in the meeting, including the news media, what they can or cannot disclose and report on when you come out of that executive session. All legal requirements that you had for public meetings that are open to the public are still applicable for executive sessions. So again, your notice requirements, the location of your meetings, minutes being taken, all of those are still required to occur when you're holding an executive session. So as I mentioned, or you've probably gleaned by now, you can't have an executive session just because you want one. There's only specific reasons for it. Now, there's a whole host in the statute. This program won't cover all of them because a lot of them are specifically available to, say, universities or public health hospitals. So what we've done is kind of combine all the reasons that cities could logically assume they might be able to have an executive session. So the first reason, and one of the most common ones, is to consider the initial employment of a public officer, employee, or staff member. What's key here is you can't hold an executive session to fill a vacancy in elected office or on public committees, commissions, or advisory boards. There's a caveat at the bottom, kind of in a salmon color, that talks about hiring your chief executive officer. For most cities, that's your city manager. Before you go into an executive session, say to interview candidates or to deliberate on which candidate you want to hire, what's important to know is that you have to have first posted the position. And that in terms of posting the position, the description and the hiring process would have had to have been decided by the city council at a public meeting, and you would have had to allow the public to have an opportunity to comment on your proposed process and job description. I do want to go back a second because I don't believe I said this when we were talking about executive sessions earlier. It is key to know that while you can deliberate in executive session, you cannot make a decision in an executive session. So if you were interviewing prospective candidates for your city manager job, you can deliberate, interview, discuss, do we like candidate A or candidate B, but you can't actually make the decision that you're going to hire candidate B in executive session. You've got to go back into a publicly noticed meeting and do that. It doesn't mean that you can't achieve consensus in an executive session. So you don't have to go into the public meeting looking at each other and being like, is it A, is it B, which candidate are we going to hire? You can come to consensus, but you can't make the decision itself in the executive session. Another reason to hold an executive session is to conduct employee evaluations. With one caveat, the employee has the right to request that their evaluation be conducted in an open hearing that the public is allowed to attend. That is a decision for the employee to make, not the council. You can hold an executive session because you are going to dismiss or discipline a city employee, or you're going to hear complaints or allegations of misconduct against the public employee. Again, same caveat is with evaluations. The public employee retains the right to have that hearing be held in an open hearing. And it's the employee's right, not the city council's right to make that decision. Reasons to hold an executive session also include the right to meet with different types of negotiators. So if your city has labor unions, you can hold an executive session to either conduct labor negotiations or to discuss how those negotiations are going to occur with your city's negotiator. You can discuss real estate transactions with the person you've hired to negotiate those transactions on your behalf. To review security programs related to the security of your city's utilities, telecommunications, or data transmissions. I always like to say here, you don't have to tell the bad guys who want to destroy your infrastructure how they can go about doing it. You can hold those security meetings in an executive session. I put Jamie and I up here because this slide talks about meeting with your city attorneys, and we are both attorneys. So, and I've put these all together for a couple reasons. So the first one under this slide is to consider records exempt from public inspection. So if you have a record that you don't have to disclose pursuant to a public records request, you can discuss that record in executive session. You also have the right to consult with your attorney regarding current litigation or litigation that's likely to be filed. That seems obvious, but what happens a lot of times is we'll get a call at the league and they'll say, okay, Patty, but I want to talk with my lawyer, but we've not been sued and I don't have any reason to believe that I'm going to be sued. So how do I get confidential legal advice from my attorney in an executive session? And you do it through the first bullet point. You consider records exempt from public inspection. And by that, attorney-client privilege. So if I, as your city attorney, wrote you a memo and I gave you legal advice, my memorandum is not subject to public disclosure. It's protected by attorney-client privilege. So let's go back. Remember I told you about the case from the Ninth Circuit about the anti-camping ordinance? So let's say your city says, I think we have one of those ordinances and I'm worried, do we need to do something? You could call your city attorney and say, hey, I heard about that Boise decision. Can you write me a memo about whether or not we have an issue here in, say, Portland? And your attorney writes a memorandum, and then you would call an executive session of your council, and the reason for it would be to consider records exempt from public inspection because you're going to inspect the memo from your attorney. And then you have your attorney invited into the executive session, and they can give you legal advice and their opinion and options in that type of protected setting so that the whole world doesn't hear your attorney's advice. You can also, as the last bullet point notes, hold an executive session to conduct trade negotiations where the city is competing with other governing bodies from other states. I don't know of anybody who's done that yet, but you do have the ability to do so. So what happens if you have an executive session that's not allowed? So it's an accidental. I don't believe most cities, again, ever intentionally break the law, but there have been instances where an executive session was held that was not permitted. So the Oregon Government Ethics Commission, and we learned a lot about that commission when Jamie gave the presentation on ethics, they're going to be the entity that investigates allegations of holding impermissible executive sessions. And they can levy fines against city officials. And it's important to note that the fines aren't imposed against the city, it's imposed against the city officials themselves. And one thing that I always recommend is that before you have an executive session, you call your city attorney first, describe what you want to do in executive session, why you think you're permitted to do so, and have your attorney give you the go-ahead. And the reason I do that is buried in the statutes. It's almost kind of a safe harbor provision where if you talked with your city attorney and they told you you could have an executive session for that reason, then typically you don't see the Ethics Commission issue fines. So particularly for the smaller jurisdictions who may be watching, I know that sometimes asking someone to call your city attorney seems almost insensitive because it's super expensive or you really watch that budget line tightly. What I would tell you is it is worth the investment in calling your city attorney before you have an executive session, because getting their protection that it's okay is way better than having your counselors and your mayor being fined individually for inappropriately holding an executive session. When we talk about public meetings, one of the big things that always comes up is public participation in meetings. And there's this misconception out there that Oregon state law requires the public to be allowed to participate in your public meetings at the local level. And for the most part, that's not really true. Oregon's public meetings law is what we at the league like to call a public attendance law, not a public participation law. And by that I mean the Oregon public meetings law requires you to allow the public to attend your meetings. For the most part, it does not require you to allow them to participate by, say, giving public comment. There's some notable exceptions to that. The most common ones are in land use hearings or during your budget committee hearings. But that's really not the end of the story, because even though under state law, so for those of you who are long-term officials getting excited thinking you can get rid of public comment, that's probably not true. Because most of the time what Jamie and I see is city governing documents require public participation at the local level. So your charter, your municipal ordinances, or your council rules of procedure require public participation during your council meetings. So when people say, why do the public get to participate? Most of the time it's because of your local law, not because of the state's public meetings law. And what's interesting, or at least important to remember when it comes to public comment is protected speech. And when lawyers like me say protected speech, we mean speech that's protected either by the First Amendment to the United States Constitution or in Oregon by Article 1, Section 8 of the Oregon Constitution. So once you allow people the opportunity to make public comment, that comment then triggers certain constitutional protections. And we, as local officials in Oregon, have an obligation to be mindful of our citizens' constitutional rights and make sure that we take every reasonable step to not inadvertently hamper those particular rights. So a lot of times public comment becomes contentious, or sometimes it feels mean-spirited. For those of you that have been to city council meetings or have been counselors, it's my personal experience that most of the time the public doesn't get up there to tell us we're doing a great job. They seldom tell us that we're wonderful human beings and they love the work we're doing. In my experience, we are usually being told that we stink, that they wish we didn't exist, or we're being called names. I myself have been called a Nazi, a liar, and several curse words that I won't repeat. And so when those types of interactions start happening, it's really common for city officials to contact Jamie or I or your city attorney and say, there's got to be something we can do about this public comment because it just seems really unfair to us. And there's certain things that we can do, but probably not as much as you want. So what the Constitution, both federal and state, doesn't allow us to do is what we call in the legal world content restrictions. So we can't regulate the words that are coming out of people's mouths, per se. So we can't say that the public can't call us meanie butts or weirdos or losers. We don't get to regulate what they say to us. But we can impose what's called time, place, and manner restrictions. In other words, we can issue rules that dictate what time public comment can occur. So we can say, if you want to give public comment, you only get to give it during this portion of the agenda. You can say public comment is limited to 3 minutes per person. Public comment is limited to an hour and only 3 minutes per person and kind of first come, first serve. You can dictate the location of where the public comment happens. So you can set up a specific podium, and that's where public comment has to be made. If you're in a smaller city council chambers, I've seen some cities where they paint a line on the floor, and public comment has to be made from that position. You can sometimes limit the content in a limited way. So for example, sometimes I see councils that have two types of what I'm going to call public comment. So they have public comment for items that are not on the agenda, and then they have public comment for specific agenda items. So let's say you have two ordinances that the council is going to discuss. A lot of times you'll see councils who will have public comment after each ordinance, and it's supposed to only be limited to that ordinance. And those types of rules are okay. And then after they've done all their business, you'll have public comment for anything not on the agenda later, and that's where it's kind of a free-for-all for people to say whatever they want. You can, the thing to remember about all of these rules, though, is you have to treat everybody the same. So let's say, for example, your rules say that public comment is 3 minutes per person. But man, you really like what Judy has to say. She's a talker. She can go on for a while, but she's got some really key points. Well, you can't give Judy 4.5 minutes for her public comment, but you only give Al 2 minutes. That's not how it works. Everybody has to get treated the same in terms of their time limitations. A lot of times what I found in working with councils, when they want to give somebody more time during public comment, it's not because it's public comment they're unaware of, it's because the person's going to talk about a specific project or community. So for example, when I was working as an in-house attorney, my council was always really keen when Girl Scout cookie selling time came out. They really wanted to invite the local Girl Scout troop to the council meeting to kind of talk about why they sold cookies and what they got to do with the cookies. And they would always complain, it's not enough time at public comment, it's not enough time. And I would say, then put them on the agenda and then give them as much time as you want. Make them a specific agendized issue, and then they don't have these time restrictions. But when you're in the public comment period, everybody gets treated the exact same way as everybody else. And the reason you want to do that is, remember how I said earlier, you can't discriminate on content, you can't regulate the content of what people say. Well, that also applies to essentially liking some person's content over another person's, because that's a form of discrimination in and of itself, or a violation of somebody's constitutional rights. So if you go back to Al and Judy, if you give Judy more time, what you're inherently saying is Judy's content, the content of her speech, is given more time than Al's. And that in and of itself is a discrimination between the content that's occurring. And we can't do that. So at some point in your career, it's not unlikely that there will be somebody at your meeting that you want to have removed. And normally it's because this person is being difficult. And so we are constantly asked, can we remove people from our council meetings? And the answer is yes, provided the person is actually disrupting the meeting. And by disrupting the meeting, we mean preventing you from holding the meeting. So when you have those people who are sitting in the audience going, oh, really? Listen to this woman. Oh my gosh, this is just, that's super annoying. I would argue it's disrespectful, but it's probably not preventing you from conducting your meeting. So it's not really disrupting the meeting in the way the law looks at disrupting the meeting. But on the other hand, if you had somebody who was screaming and yelling and raising their voice and refusing to leave their public comment podium after their time had expired, they are disrupting your public meeting and they can be removed from the meeting. One caveat I would say, I once met with a city official, and the people removing the citizens were senior citizens. And I would encourage you to make sure that the person who's removing someone from the meeting is preferably law enforcement officer, or at least somebody you've specifically identified as your quote-unquote sergeant-at-arms. It shouldn't just be random members of the city council. So the logical next step is, well, then can I arrest somebody for disrupting my public meeting? Sure. Oregon has a disorderly conduct statute, and that disorderly conduct statute specifically prohibits people from disrupting lawful assemblies, and a city council meeting is considered a lawful public assembly. So law enforcement can arrest people for disrupting that public meeting. What I always like to tell people as an attorney who worked for law enforcement for a really long time is that those law enforcement officers are held to much different standards than you are as a city councilor. So it's always been my advice and preference that the decision on whether or not somebody should be arrested or not arrested is a decision best left to the law enforcement officer themselves. So what I always tell people is, if you think that somebody is, disrupting your meeting and they need to be removed, they can certainly be removed, but the person who should be deciding whether or not they need to be arrested is the law enforcement officer themselves, because they're the person who's actually has the authority to make that determination. So a lot of times people will say, all right, look, Patty, we had Joe Smith removed from our meeting, like 4 meetings in a row. And the last time he was even arrested because law enforcement was so tired of him disrupting the meeting. Can we just suspend him from the next 5 meetings because he's just going to continue to disrupt them? And the answer is, honestly, probably not. The federal courts in our jurisdiction have been pretty clear that past behavior at a council meeting doesn't inherently mean that same behavior is going to happen again. So you can't preemptively prohibit people from coming to your meetings. And I think at first blush that almost seems unfair or super frustrating. But if you can take a step back and think about it, that's really like one of the key rights we're supposed to have as citizens, right? Is we've elected you to hold this office, and while you're in office, you have all this power and authority over my life. I, as a citizen, should be allowed to seek redress with you. And so what the courts have said is that you really can't suspend people from future council meetings unless you have a real reasonable likelihood that they pose a threat to somebody. And what I would tell you is the posing a threat is still probably a little iffy. The courts haven't given us a bright line rule on that. So if you're thinking about suspending somebody from a future council meeting, I'm going to ask that you do 2 things first. First, you talk with your city attorney at length. And second, you talk with City County Insurance. They're one of the league's partners. And for the most part, with the exception of about 4 cities in Oregon, the 4 biggest ones, they provide a lot of our insurance coverage. And you're going to want to talk with their attorneys as well before you think about suspending somebody from a future meeting. So let's talk about a few best practices. The best practices are not just mine or not just Jamie's. These are ones that, yes, we've developed over time in working with city councils, but they're also ones that we've taken from city managers who've been in the field for a long time, from other city attorneys who've been practicing for a long time. They're just our suggestions. They're not legally required, so take them as you will. The first one that I highly recommend is that you establish procedures. And by that I mean you establish council rules of procedure. And we talked about this a little bit in an earlier session, but it's worth re-mentioning here. Because again, council meetings go smoothly until they don't. And if you can establish the procedures by which you're going to run those meetings, you're going to have a lot easier time getting through them. And what's more, it's not just about establishing them. Each member of your council should know what those rules of procedure are. You shouldn't just rely on the mayor as the chair or your city attorney to be familiar with them. It's your meeting as well. And because it's everybody's meeting, everybody should know the operating rules and expectations. So make sure you take some time every year to pull them out, look at them, and familiarize yourself so that you can be a good teammate while you're in these public settings. The other thing that I would suggest, because I've seen it create conflict before, is establish an agenda setting policy. So a lot of your charters are going to say that the mayor is going to set the agenda for a council meeting with your city manager. But what if the council president wants to add something to that agenda? If you don't have an established procedure for how other councilors get to put things they want onto the agenda, I'm going to go out on a limb and say that at some point you're going to have a conflict amongst yourselves. So while you're crafting or reviewing your rules of procedure, if you don't already, also make sure you set up a procedure for how people can put things on the council agenda. Some tips for public comment, common procedures that I share. One of the best things I think is before you start a public comment session is to have your chair, it's usually your mayor again, give the rules. So kind of state it. So for example, everybody, we're about to go into our public comment session. I want to remind everybody who's here that for public comment, we ask that you sign this form. You need to give your public comment from this podium. Everybody gets 3 minutes to say whatever they feel like. We're going to give you a 15-second warning when you're done. When you've hit the 3-minute mark, I'm going to ask you to leave. We do generally, as a council, strive for decorum and respect. We don't call each other names. We don't denigrate any member of the public. We would ask for the same respect from the public as well. If you don't follow the council rules of procedure, law enforcement officer Joe is in the back, and Joe will remove you from our meeting. if you can tell the public what the rules are in advance, it sets a tone and it becomes kind of routine for the whole community to follow those rules. I'm a big fan of utilizing sign-in sheets, not because you're trying to track who's attending, but because that sign-in sheet can then be given to the mayor, and the mayor can list the people in the order that they signed in. So it's not, who's next, anybody else, It's literally, okay, here's a list, and it's just a little bit more structured in how the public comment section reads. The third bullet point is sometimes hard. It's not, again, not a requirement. This is just my recommendation and the league's recommendation. Public comment, by its very definition, is a comment period. It's an opportunity for counselors to listen. It's not supposed to be a back and forth engagement with the public. In my experience, when the counselors start engaging directly during public comment, all of the rules regarding public comment go out the window, and we often can end up in conflict. And that can be hard because a lot of times we get really useful information from public comment, right? They raise an issue we didn't know about, they've asked a question we didn't know that we ourselves had, and you want something to do with it. So a lot of times what I'll see in that opening remark from the mayor is the mayor will say, we're not going to engage in a dialogue, but please know that if you raise an issue of concern or you ask a question, our city manager is taking note of it, and our city manager will themselves or have another staff member loop back with you as soon as possible. So it lets the public know they're being heard and they're going to get a response, but it stops that back and forth from happening and any questions about why it can't happen as well. Some things I'd like you to think about in terms of helping your council meeting run smoothly. So the first bullet point I purposely put there because this was always a giant personal pet peeve, for lack of a better word, when I staffed my city council. Please read your packet, your whole packet, and don't read it as you're walking into the council meeting and frantically trying to read it as we do things like the Pledge of Allegiance and we run through like attendance. Read it in advance. And read it in enough time that if you have questions or things don't make sense, you can call the city manager and ask. As a former city staffer, I can tell you that, I'd be up there at the podium answering questions, and you get a counselor who would ask you a question, and you'd say, yes, counselor, the answer to that question is the first sentence of the packet. It's a little disrespectful to staff. It's also not a useful use of your time. So if you read your packet in advance, and let's say you've got 3 issues or questions, if they're complicated and you tell your city manager 2 days in advance, they might be able to have that information and those answers for you at the meeting. From a former staff perspective, it would sometimes be super frustrating to stand up there and just know if they'd asked me the question 24 hours in advance, I would have been able to give them an answer instead of me saying, I'm sorry, counselor, I'm going to have to get back with you and I'll have that information available to you at your next meeting. So the sooner you can get your questions, the better. And I also always liked, I had a council president who would always call me up with his questions, and every once in a while he'd say, now Patty, I'm still going to ask you these questions in the public meeting because I think our citizens could have the same questions, and I just want you to know that I'm going to ask them. And what that always triggered for me was, okay, then when I give my opening remarks, I'm going to try and hit those questions in advance just to kind of make the meeting run a little bit more smoothly. Again, we talked about it again, reiterate it, read, review, and follow your rules of procedure. Arrive to your meetings on time. It can be distracting to have people come in late. In the real world, people don't always run on time. Accidents happen. Kids don't eat when they're supposed to eat, and they make you late. But do your best to be on time. If you can't attend a meeting or you know in advance you're going to be late, call the city manager or the mayor, whoever your city requires you to call. That way you can make sure that you have a quorum. If you've got a 5-member council and quorum's 3, and 3 people know they're not going to show up, make sure they know that in advance so you can cancel the meeting. Approach every single agenda item with the belief that everyone has something to contribute and may have information that you do not already possess. I think a lot of times we go into settings and meetings thinking, I already know everything I need to know and I know how I'm going to vote. And maybe that's true. Maybe you're not going to learn anything new during your council meeting and your vote's not going to change. But I would encourage you, after almost 20 years in local government, to keep your mind open. because I myself have been in several situations where I was in a public meeting and I learned something I didn't know before. And I would say that if I was a voting person, it would have definitely impacted my vote. And I think that that's probably true for some elected officials as well. Avoid making assumptions about people and listen to learn. And part of listening to learn, particularly in the technology world, is giving people their due attention. So I think technology is super great, but if you're in a public meeting, let's say an in-person meeting, and you're sitting at the dais and you're typing away on your laptop while the public's speaking to you or another counselor's making comment, it's not always clear, are you typing because you're taking notes or are you shopping on Amazon? So be mindful that whatever you are doing in listening, it appears as if you are actively listening to the person you're talking to. I think that's even more particularly appropriate when you're doing things like Zoom meetings. Because for myself, it's super easy to get distracted and just kind of start responding to email when I should probably be listening to what's transpiring in front of me. Focus on the policies that are being discussed, not the people behind it. So I read an article a couple years ago. It was super interesting about how we all carry around these ghosts with us. And the ghosts are essentially ghosts of interactions with people we've had in the past. And what they were talking about was if you've had negative interactions with somebody before, you can kind of carry that forward with you in every conversation you have with them. And so my dad always used to like to tell this story about my ex-brother-in-law. And on a scale of 1 to 10, 10 being he was an axe murderer, horrible person, my brother-in-law was never a 10. He was probably like a 6 or 7 most days. But the problem was he was a 6 or 7 every day, all day, every day. So even when my ex-brother-in-law was really acting at a 1 or 2 level, it seemed like a 10 because it had just been that pervasive and that bad. And so I think it's normal to bring those past experiences into us. But in reality, if we're trying to find consensus and work as a team, what I would encourage you to do is, again, not focus on who's speaking, who's bringing forward the idea, because you could have negative reactions to them. Focus on the idea itself. And it can be really hard, but I think sometimes we ignore the message because we don't like the messenger. Acknowledge other people's reasonings and make sure you explain your own reasoning. So you don't have to have unanimous decisions as a council, and you don't have to agree with every member of your council. But if you can at least acknowledge that you're listening to their reasoning and their rationale, even if you see it differently, and also explain your reasoning and rationale, it might be easier for you to find that common ground. Or at a minimum, even if you can't find common ground and you're going to end up with a split vote, you can at least end up with that split vote in a respectful way where you both walk away from it thinking, well, we just didn't disagree this time, but the city still moved itself forward. And other things, we touched on this a little bit, keep distracting things off the dais or away from your computer screen if you're still doing this via Zoom. And again, a little plug out, I think I have a slide on this, let me go to, I do, tips for virtual public meetings. This is a new slide for the league. We've never had this before, but given some of the things that we've experienced in virtual meetings or we've seen on the news, it seemed relevant to put in this year. First and foremost, test your technology before you use it. And that, I mean, before you use it, before the meeting starts. So if you are going to have your first Zoom meeting and you've never been on Zoom and the meeting starts at 7 p.m., probably shouldn't try logging into Zoom for the first time at 6:59 p.m. Test the product to make sure it works. Arrive early to your meeting, even if it's a virtual meeting room, in case technology fails. I have been using Zoom now for 7 months. I feel like I'm on Zoom on some form or fashion at least once a day, and I can tell you that at least once a week I run into some type of technology glitch I have not experienced before. So arriving early allows you time to deal with those unexpected issues. Make sure you have appropriate lighting and sound. I know we don't always all have the best internet connections, and there's some things that we're not going to be able to do about it. But it's really distracting if you don't have the right light so people can't see you, or if your sound comes off as muffled. And that goes also in terms of with distracting stuff. I'm a big fan of kids. I love them. I love dogs. Cats are okay. So I'm super excited when kids join Zoom meetings, and dogs are phenomenal. But maybe ask yourself, should my dog really be barking nonstop while we're trying to do this sewer rate increase? So just kind of think about those things. We recommend that you have a policy that requires all participants to be muted upon arrival, and then that they remain muted unless they have specific permission to speak. It's not because we're worried about people jumping in and talking all at once. It's because of that distracting background noise that can kind of take away from the actual meeting that's happened. Remember to remain professional in your words and in your appearance. It's super easy to get a lot more casual when you're not in that formal setting, whether it's with your tone, your words, or your dress. I have not personally experienced it yet, but you know, the newscast is frequent with people who have shown up to Zoom meetings in their underwear. Seems like that would be bad form for a council meeting. Remember, in my opinion, to be gracious. And by that I mean, for a lot of us, this is a whole new world for us. We didn't have council meetings via technology, Zoom, Teams, whatever. We were always meeting in person. So be a little bit more gracious with those people who may not be as savvy as you are with the technology, who may be using this for a first time. We're all learning how to deal with this, and so a little bit of grace never hurt anybody. If you plan to record the meeting, and my guess is for most of you, you are in fact recording these meetings, I would make sure that you let people know that you're recording it. And the reason I say that is people may not inherently know that you are recording their image and that it's now going to be posted on the city's website. And so you should let people know that that's something that you're doing. Don't allow the fact that you're in this meeting and that people can't actively see what you're doing at all times to do other work. Still give your council meeting the same attention you would have given to it if you were in an in-person meeting. And if you have the ability, depending on the platform, we always recommend that you have people identify themselves in their profile. So Councilor Joe Smith, Ward 4, Mayor Jane Doe, whatever. If it's the city attorney, Patty Movahill, city attorney. Just so everybody knows who is who and you can identify yourself in your profile picture. So that's it. That's what we have for public meetings and best practices. We will see you in the live Q&A. Chat soon. Hi, everybody. Welcome back from lunch, and hopefully you enjoyed the session on public meetings. I think Jamie and I can both agree now, having watched ourselves on video, yeah, it's been interesting watching yourselves, hearing yourselves as well. I know that we already have some questions in the queue, so Lisa, if you can give us our first one, we'll start with it.
Okay, first question. Is a study committee of council members where there are fewer members than a quorum still a public meeting?
Not technically, but I'm going to put a caveat on that. So if it's less than a quorum, you don't have a public meeting, but you have to be mindful of not inadvertently creating a serial meeting. So let's say we had a council of 9, your quorum's 5. And you've got 3 of you that are regularly meeting and talking about things. That's not a public meeting. But remember, if the 3 of you, or even 1 of you, brings in 2 other people in the loop, you've got a serial meeting. So you don't technically, if you have less than a quorum, but you're gonna have to be super, super careful about not inadvertently creating a quorum through a serial meeting.
Okay, next question. Can you touch on serial meetings again? For example, is there anything that prohibits one counselor to talking to another counselor outside of a meeting, not to deliberate toward a decision, but rather discuss an idea?
Yeah, that's a great question. So I will preface by saying serial meetings are some of the most complicated and some of the most frustrating for elected officials. So if you go back to the early part of our slides when we talked about public meeting, there's a slide in there that specifically says that the Attorney General for Oregon says that a public meeting isn't just when you're going to make a decision or deliberate on one, it's also when you're gathering information. So that one-off conversation you're having with the counselor to kind of just discuss and get a feel for it, or maybe shoot ideas off each other, try to, where are they coming from? That is gathering information. And if you get to a quorum, you could end up with a serial meeting. So this is the most frustrating part about virtual, because I think serial meetings are easier when I have a room full of people I can visually show this to. But let's say again your quorum's 5 because you've got a 9-member counselor. You can certainly talk to 2 people. That's fine. That's not a quorum. That's not even close. But if you add a 3rd person, so if you've got A and B decides to talk to C about it, you're still fine because you don't have a quorum. But if A is like, well, B talked with C and I really have a good relationship with D, so maybe I should loop D in, and that's still not a quorum. They're right, because now you're at 4 and that's not a quorum. But if any one of those 4 people decides to loop in E, we have a problem. So you can do it. I mean, you could talk with 4 people and be fine, but you're going to have to be 100% convinced that you all are actually keeping it to those 4 people, that you're not reaching into a quorum. And so when people call and ask Jamie and I, you know, what should we be doing? Should we be talking about the stuff after hours? We're always giving you the most conservative advice possible, saying you should really be doing city business in the public forum. Whether that's a public meeting or a work session. Work sessions are still publicly noticed, but typically you don't let the public comment during them. That's the safest way to do it, because it's our experience that serial meetings aren't deliberate. It's never intentional usually. It's just, you know, we thought we were fine talking to 2 or 3 people, but we didn't realize one of those people was going to talk to somebody else who also talked to somebody else, and now we ended up with a quorum. So 2 is fine. You just got to be mindful that nobody else goes up to that quorum number.
Okay, next question. Any suggestions for public comment for remote meetings? Those that log in can type their interests, but those on the phone cannot.
Yeah, so we've been experiencing this a lot because we've had some public, obviously this is it's not a public meeting, but we're trying to take public comments. I think it's difficult. I think you got to figure out what's going to work best for you, and I honestly think right now it's trial and error. So what we've tried to do, what I've seen some success, particularly with my board, is that when we know that we have people on the phone, what we do is we typically have our chair kind of start with the comments he can see, so he can visually see somebody raising their hand via Zoom, or we can see a question in the chat feature, but then kind of his presider notes, so to speak, will trigger that before he moves on. He would say, is there anybody on the phone who has a question? If so, I'm going to give a 10-second pause so you can unmute yourself and ask. Now, worst case is you could have 2 or 3 people on the phone who do it at the same time, and then we're going to have to kind of juggle how we respond to those. But that's how we've been doing it locally. I don't know, Jamie, do you have any other suggestions?
Yeah, I think some cities, they ask for public comment ahead of time, so they issue the agenda publicly, say a week in advance, and then they say if you have any public comment, you can submit it in writing to this person at this email address, and then they will be read into the record. So that's I'd say that's more of a supplemental option than really the only option. But yeah, it's really just determining, you know, your constituents and what works best for them, and figuring trial and error. It's a messy process, but you'll figure it out, and you'll get a good process that works for you and your city.
Okay, next question. Can counselors send info via email, not inviting discussion, to other counselors using blind copy? Does this run afoul of the serial meeting issue?
Potentially. And so the reason I say that is because, remember, you're still gathering information, so that in and of itself can be a meeting, and you're going to have at least one counselor who's talked with sending the email to all of the other councils to create a quorum. That would be one interpretation that could possibly happen from the courts. What I would suggest people do is that, so remember, the quorum is, the public meetings is only applicable to the public body, so to your city council. So it's not applicable to your city manager, for example, because your city manager is not part of the council. So what you could do is, if you've got information that you want to share, you could share it with the city manager, and the city manager could say put it in the council packet. Or if the packet's already gone out and this needs to be supplemented, they could certainly send it to all of their council using the BCC feature, so you can't reply all. Because again, then it's the city manager who's talking with everybody, not the council talking amongst themselves, or one counselor talking to every other counselor. And that's what we do at the league when we communicate with our board. So if I have to communicate something to my board outside of a public meeting, it comes through me because I'm not a member of their governing body, and I always send it using the BCC feature. Because in my experience, if you don't use the BCC feature and you say do not hit reply all, and you put it in bold in 48-point font, somebody is still going to hit reply all. I had a mayor one time who constantly replied all. But so be leery of it if you're a counselor yourselves. I think the safer course of action is to use your city manager. If you don't have a city manager, your recorder, or your city attorney. Do you agree?
Yeah. Was there a question about voting in that, Lisa? I may have misheard the question.
No.
Okay.
Okay, Bill Meyer, it says you would like to ask a question about serial meetings. So if you want to unmute yourself, you can go ahead and ask your question.
I think, am I unmuted? I must confess I did a little research while you were talking about serial meetings, and one of the advice online related to serial meeting, it says that you avoid one-on-one conversations. It says that one-on-one conversations are permitted as long as the views of the other members are not shared in these conversations. So getting back to your, let's take a 5-member mayor. A talks to B, and then B talks to C, but B doesn't tell C what the conversation was, doesn't share any views, simply has a conversation with C, and then C talks to A without mentioning the views of the other members. Is that a violation of the serial meeting? And again, if they don't share the deliberation with the other members.
So I'm going to say we don't know, and that's a frustrating question. And the reason I want to tell you this is so the problem with serial meetings in Oregon is that the serial meeting prohibition was created by the courts and not by the statute. And so some of the advice we give is a guess. So what I would tell you is that if any counselor talked to every counselor, even if they didn't share the conversations, you could still, under some of the readings that some attorneys have of the court decisions, is you could still have a serial meeting. And so the league, because we represent all cities, a lot of whom don't have city attorneys themselves or their city attorneys charge them by the hour, always take the most conservative approach possible. So I would never recommend that somebody take that action. What I would instead do is, let's say, for example, you're the mayor and you're trying to figure out, okay, look, we seem to have a split on the council, right? Like, we're trying to move this ordinance forward and I've got one side here and one side here, and I'm just trying to hash this out. If your city manager maybe did the investigating for you to see if the city manager could find out where that middle ground was, where the compromise was to do an amendment, that would be fine because the city manager is not a part of your council. But if you did it yourself as the mayor, I think there are some interpretations of the Supreme Court's decision on serial meetings that could be risky, that might consider that a serial meeting. And I say that because when you read the Supreme Court's decision in the TriMet case, what's clear to me is that it's those kind of sidebar conversations that the court almost seemed to find offensive. So they, in my opinion, and I think a lot of attorneys agree, they kind of read this concept of serial meetings into the statute. Like, if you look at the Oregon statute, you're not going to see a concept of serial meeting. It's really something the court kind of created. And I think the reason they did that is because they don't want counselors to have those sidebar conversations, particularly having them with multiple people, to essentially kind of make decisions or gather information that the public can't participate in. So I think there are definitely cities who take a much more loose interpretation of that decision than the league recommends, and that's certainly fine. Your city should do whatever it feels comfortable with. But I would talk with your city attorney and do the risk-reward kind of evaluation. From my perspective, I always suggest that it's better to not have counselors talking to every counselor or up to a quorum, because I do think that's arguably risky behavior, given that we're relying on the Supreme Court's decision instead of a statute with finite rules. What do you think, Jamie?
Yeah, I agree. I think, you talk about what's written in the words of the statute and then that being interpreted by the courts. I think it's also it's important to realize and look at the spirit of the law. So public meetings law and also the public records law that we discussed earlier, the spirit of the law is really focused on transparency and having the public's business done in front of the public. So those sidebar conversations, the one-on-ones, while maybe not per se illegal, it kind of goes against the spirit of having the public there during all the city and elected official deliberations. So it could be completely fine legally, but I would argue it just goes against the spirit of the law, and I don't want to be that city who does get the issue brought in front of court to be the sample for the whole state.
Yeah. Did that help, sir, hopefully?
I'll go up on that. Again, to try to avoid a serial meeting on my part. Mm-hmm. And I'm talking, counselor approaches me and talks about an issue that we know is coming before the council. But I don't ask that counselor now, are you going to talk to anybody else? And I have no knowledge that they may talk to somebody else. So if I don't ask that question, and I have no knowledge that they may be sequentially talking to somebody else, am I at risk, or who is at risk there? The entire council, or that second counselor at that conversation? And again, I want to be able to talk to my fellow counselors, but I also don't want to jeopardize the city or my other counselors. So it's kind of a tough one.
It's a great one, and people have been struggling with this issue since the decisions started coming out from the courts. So to answer your first question in terms of who's in trouble, it could be both. It could be you individually, because individual counselors had essentially what's happened when you have a serial meeting, what that means is you've had a meeting that was behind closed doors, right? So it's almost kind of a de facto executive session. And you can be held personally responsible for participating in one of those. Now, whether or not it's knowingly or not, it may be different, but you could still run into some trouble. The second thing is that the city itself could also be in trouble. And so what I always suggest, particularly after we have these trainings, so we do these every 2 years, and Jamie and I always get a series of questions immediately afterwards, is you should go back and you should have a conversation, particularly if you're new, with your city manager or your city recorder, your mayor. What's the city's policy right now? Like how do we, because there's a very real chance that your current city already has a policy in place that talks about when it's okay for you guys to be talking about city business, if there's a procedure in place for kind of avoiding serial media violations. And if there's not, then have that conversation with your city administrator and your mayor. What's it look like? What are we safe with? What are we comfortable with? What works for us? If you can't have that conversation, because not every council necessarily wants to have those type of conversations, then what I always default to is, what are you personally comfortable with? And I kind of always look at it again as a risk reward. If I know that there's a chance that we could put the city in jeopardy, or I myself could be in jeopardy because I unwittingly participated in an executive session by essentially having this serial meeting being part of the chain, I choose not to participate in that risk. So I have a lot of city councilors or mayors who will say, you know what, I've weighed the pros and cons, and I'm just not going to. So when I have a councilor try and pull me aside and talk about it separately, I always say, you know what, I don't really want to do that. Let's schedule a work session, and let's hammer it out at the work session, and then we can talk about it later. But I want to hear everybody's thoughts all at one time. There's also the theory that I've heard from some people, and if you go back, we had a lot of conversations about building a team. And building a team is we all work together. And so there's another philosophy out there from some experts who study teams and dynamics and groups, and that when you have like these one-off sidebar conversations over here, you're actually almost kind of creating subsets in your team, right? Which might be damaging to the full team, because it's always Patty and Jamie talking behind the scenes about stuff, and they come into the meeting and they're already seemingly a little bit ahead of everybody else. And so I say that to say that you need to be mindful of creating those different team dynamics, but it's really going to be an individual city council decision about how you want to handle these types of issues. And then if you can't find consensus in a council, what are you going to be personally comfortable with yourself as an elected official? And like Jamie said, keeping in mind the spirit and intent behind the law, which is we're supposed to be doing the city's business in front of the city and the citizens themselves. Does that help?
Yeah, thank you very much. I appreciate it.
Absolutely. Do we have other questions, Lisa?
Yeah, so we have about 4 questions and a little less than 10 minutes.
Okay.
Is it legal to not allow the meeting recordings to be publicly available?
Probably not, unless it's an executive session. So if you have an actual digital recording of it, unless there's a specific reason and the public records law to keep it exempt, you're going to probably have to disclose it. And if it was a public meeting, I don't know how you're going to keep it out of the public record when there's a request. You can certainly do that for executive sessions, but an actual publicly noticed meeting, I can't think of a way where you would be able to keep it out of.
Just to clarify, I guess there's a difference though between having to make the recording or record public versus having to post it on your website. So if you're already posting, you have a habit of posting your minutes on the website, you don't necessarily have to post then the recording on your website as well. But if the member of the public asks, hey, I missed the meeting, or for any reason, and I wondered if I could have a copy of the recording, then under the public records law, you would have to provide it. So there's just the difference there. Just know that there's a difference between like having to post it on your website versus having to provide it to a records requester.
Good point, Jamie.
Okay. Regarding serial meetings, what if a topic is not on the agenda, you are discussing future ideas?
So I still think it's risky. If it's related to city business, you're still gathering information. So what I always say, again, and I want to preface this by saying, this is the league's advice, and we take the most conservative approach possible because we want to speak for all cities, even those who do not have the same legal resources as some of the big cities. So Jamie and I both live in Salem. Salem has probably 7 or 8 full-time attorneys on staff. They might take a different opinion than we do. And that's because we would represent, let's say, a city of Dayville, who doesn't have a city attorney on staff. What I would tell you is, can you repeat the question? Because now I've lost myself trying to explain where we're going.
What if a topic is not on the
Yes.
agenda?
Sorry, everyone. I would tell you my general rule of thumb is if you're talking about something that is city business or could reasonably be city business, you need to be mindful of that potentially being a meeting. So for example, let's say there's no water rate increase discussion on the agenda for this year. But in the course of looking at the city's budget and overall financing and talking with the city manager, you know that you've got an aging infrastructure and that at some point you're going to have to replace that water infrastructure, and that's going to require a water rate increase, even if it's 2 or 3 years down the road. If you start having conversations with that about your colleagues, it would be hard, I think, to make the argument that that's not city business. So maybe it's not on an agenda, and maybe it's not planned on an agenda for 3 months, but you probably are talking about city business that will come before the council at some point. So you are already in the initial gathering of information stage for issues that could be on the agenda. What do you think, Jamie?
I don't disagree at all. In fact, I would even go a step further and say, even if it's not on an agenda item at all in the near future, it involves city business, so I just wouldn't discuss it. I just take the most conservative route just to be safe.
Right, and again, go back and have these conversations with your city recorder, your city attorney, find out what your comfort level is. I don't disagree with some of the less conservative approaches. I mean, when I was a city attorney, my city, we had 80,000 residents and we had 9 full-time attorneys. And I guarantee you, we took a lot more liberal interpretation of the law than a lot of my smaller cities that were just next to me, and that was because, quite frankly, the city had attorneys on staff, so if they were wrong and they got sued, we had the resources to litigate and it didn't cost the city any money. And, my mayor used to jokingly say, I pay Mobile Hill the same whether I work for 40 hours a week or 80 hours a week, and he wasn't wrong. So have the conversation with your city to figure out the risk reward for you, and just know that Jamie and I will always give the most conservative approach possible.
Okay, next question. In regards to conducting research of relevant criteria sources, packets, ORS, local, county, state, federal law, and agencies, does the approach differ between meetings, hearings, and appeal hearings?
Possibly. So the hearings you have to worry about the most are going to be your quasi-judicial hearings. Those are typically going to be your land use decision hearings when you act in that capacity, or you're hearing an appeal. So some cities, for example, will have an appeal process related to permits. So let's say your city has a business permit and your city manager decides to revoke somebody's permit, they can appeal it to the city council. So whenever your council is acting in a quasi-judicial capacity, you do not generally, you should not be getting information that's not handed to you from the hearing itself. And because what that would be considered what we call in the legal world ex parte communication. And when you're acting in your quasi-judicial capacity, that's when you're basically acting as a judge. And just like a judge in court, you need to be making your decisions off the information you learned in that court hearing. So when you're in a land use hearing context or you're hearing an appeal of some type of permit revocation, anytime you think you're in a quasi-judicial contact, you doing your own outside research is not advisable. You really need to be making your decisions based on what happens in the hearing. And if you don't think you have enough information, then the response is to work with your city manager or city staff to get that additional information into the hearing in a way so that you're learning about it through that venue instead of doing stuff outside the record.
Okay, final question. I have been elected but will not swear in until January. Can I have private discussions with other counselors?
I get this question a lot. So the public meetings law only applies to the members of the governing body themselves. So until you become a governing body, so on January 1st when you take your oath, you are not somebody who has to worry about the public meetings law or the quorum issue. Now, if you're talking to people who are sitting city council members, and let's say again you've got a 9-member council, if those 5 members are all talking, they have a quorum issue. You may not be part of the problem, but they could themselves. The other thing I would suggest, and this is just a matter of what I would call kind of pre-team building habits, is before you start having those conversations, I would at least have a conversation with your city manager or your city administrator and ask for their advice and their thoughts. What I have seen happen in some cities is soon to be elected officials are super excited to kind of take the reins and get on and start working on this stuff. And they start having these private conversations, and it relates in maybe some hard feelings with other members of the council who aren't being included. Or you're making these decisions and you don't have all the information from staff that maybe you should. And so it kind of starts off the road a little rocky in January when you've already had these discussions. So I would encourage you to loop back and go back and have a conversation with the city manager first and just say, look, this is what I'm thinking about. I kind of want to have these conversations. Do you have a preference? Is there kind of some team dynamics that we need to work through? Just so that you don't start off on the wrong foot. That you kind of, and again, it doesn't mean that councils can't shift and change with new members. I think change is a good thing. It's a scary thing, but it's a good thing inherently. But you want to make sure you're not kind of tipping the proverbial apple cart. Jamie, what do you think?
Yeah, I agree. I think the other thing to be aware of too is the public perception. So it's a great question because we do get the question asked to us all the time. So I think if you have a councilor-elect who's having these meetings with current councilor members, someone in the public might see you at the coffee shop or wherever you would be during a pandemic and kind of create an issue that might not be there. So can you legally have these meetings? Yeah, probably it's fine. But how does that look in the public's perception? That's kind of also, in addition to the law, what you want to be thinking about.
Great. Do we have any more questions, Lisa?
One more came in.
Okay.
So it says, I think what I'm gathering is that city councilors are not allowed to be lobbied like legislature is. They are making decisions long before it hits the floor by one person, talking from one to the other all of the time.
So I'm not sure I understand the question. So what I want you to take from this and what the league wants you to take from it is that the discussions you have as a council, so between councilor and councilors and mayors, we would encourage you to have those conversations and discussions in a public forum that's noticed so the public can watch. That said, you are going to be lobbied for, if you want to pass a new ordinance to say, I don't know, you want to pass an ordinance prohibiting skateboarding on City Hall steps because it seems to be happening too much and people have been injured and it's just not where you want skateboarding to happen, so you want to pass an ordinance. I would expect you to be lobbied by various members of your community and citizen groups and businesses. And those conversations I think are fine. I think that's actually part of your job as an elected official to be responsive and listen to your constituents. The conversations that we worry about from a legal perspective are the conversations between councilors and mayors that happen outside of the publicly noticed meeting forum. Those are the ones we want you to be mindful of. And the only caveat to that, again, is if it's a quasi-judicial hearing, and you will know when you're going to have a quasi-judicial hearing. I would say if it's a land use matter, err on the side that it's a quasi-judicial, or if anybody's appealing a decision that city staff made. In those instances, you don't want to be lobbied. In fact, when somebody approaches you in the grocery store, because that's probably where it's going to happen, or the post office, they see you and they want to come up and tell you, hey, that you're thinking about redeveloping or issuing approval to redevelop that site right by the school and I don't like it. That could be an ex parte communication, and so what you want to say is, look, I can't really talk about that case. If you've got questions or concerns, you want to make a comment, I need you to either show up at the hearing or submit written comments that can be read during the hearing, but I can't talk to you about that now. But you should generally, outside of the quasi-judicial context, feel free to have conversations with your citizens, with businesses about proposals before the city. That's fairly common.
When unanimous, do all names need to be listed in the minutes?
That is an excellent question. So as long as at the top of your minutes you've identified everybody who's present, then I think unanimous works because it's obviously there. Now, that said, let's say you've got a 7-member council and they are all there at the beginning. So let's say you've got 10 votes all together that night and all 7 are there for the first 6 votes. But then somebody leaves and you say unanimous, you're going to have some notation in the minutes that you don't longer have a full council anymore, so that you're clear that not everybody kept voting. So you don't have a 7 vote, you have 6, and we know which 6 were there. So that's the only exception. And I will say when the league does its minutes, we do still name everybody just out of practice in case we mess up, but I don't think it's required because you've already identified who was present, and unanimous would indicate they all voted one way.
Okay, next question. How would a council member be able to prove serial meetings?
That's an interesting question. Proof is always hard to identify. What I can tell you is in the one case where it actually made its way up to the Supreme Court, What they talked about in that instance, it was basically proven, and mostly because of email exchanges. The meeting had kind of predominantly happened over email and or the phone, but you had email messages that indicated that there had been a phone call that took place between those. So proving any type of violation of any law is really going to mostly come down to either testimony from somebody who's swearing under oath to something, or you've got some type of documentation that indicates something inappropriate occurred.
Okay, next question. Does public meeting law apply to elected but not yet seated officials?
No, so I think we talked about this a little bit in the public record section. So your obligation as an elected official happens when you become an elected official. So all of you that are councilors-elect or that are mayors-elect, you are not subject to public meetings law yet. But I think Jamie made a really good point when we were talking about public records, is that even though you're not subject to the law yet, and I've told you you're not subject to the law, and your city attorney may tell you you're not subject to the law, perception-wise from your constituents and your citizens, they may not know that. And so there could arguably be a perception issue that you have to address if, let's say, 3 of you who are councilors-elect are meeting every Monday or Tuesday at the local coffee shop and you're clearly talking about city business. You're correct, you're not subject to the public meeting law requirements, but your citizens may not understand that, and that could create some issues for you in terms of perception and policy and just what your citizens think, so you might want to be mindful. The reality is, as soon as you became a councilor-elect, actually probably as soon as you became a candidate, you became a lot more visible than you were as a private citizen, and things that you don't think matter will now matter to a bunch of people you have never met before. So you are certainly within your legal rights to do so, but Jamie and I would always caution you to be mindful of that public perception and take that into account when you're considering some of the actions you take.
Okay, next question. In an effort to encourage council members to get to know each other outside of their council interactions, would it be acceptable to gather as a group, all agree to not discuss business whatsoever, and then perhaps invite a member of the press to witness that no business was discussed?
There would be nothing wrong with that suggestion. The law doesn't require you to invite a member of the press to kind of check on you. In fact, the law and the Attorney General are very clear that social gatherings where you don't discuss business are perfectly permissible. It's acceptable to do it. I can think of an example a couple years ago. The national Christmas tree, the one that goes up in Washington, D.C., was taken near a community here in Oregon, and their entire council wanted to go out together, and they rode together in a van, and they just all agreed and said, I think at a city council meeting they were all going together, but they weren't going to talk about city business. I know of a couple cities who, if their meeting, let's say, starts at 6, they all have dinner together at 5:30. So the city, orders pizza or Subway, nothing, expensive. And they have this agreement that for 30 minutes before the meeting starts, they're all going to chat about their lives and who they are as people, to kind of A, get to know each other on a personal level, and then B, also to kind of set the tone where we're already dialoguing and engaging and we're working with each other, so that when you go into the official business, hopefully that momentum can kind of carry forward in the professional setting. Jamie, you have any other suggestions on that one?
No, I would almost even encourage social gatherings to that extent. I think it really helps with team building. We talked about how as a council you're a team. So having the 30 minutes reserved before each council meeting to have, the dinner or potluck beforehand, or even I guess on Zoom, having that just purely social non-city time, I think it really helps you become better counselors and a better council as a whole when you have that rapport with each other.
It's a good question.
So the next question, I think you kind of touched on this with this one, but I'm going to ask it just in case you have anything to add. Serial meetings is challenging. When wanting to develop team, it requires time and dialogue, not necessarily requiring a public meeting. I am now seeing leaders who are cautious and more siloed. What would be a creative way to dialogue without extreme cautious behavior leading to siloed leadership?
That's a great question, and it's been a problem that I think Oregon elected officials have been trying to struggle with for the last couple of years since the serial meeting rule came out. The thing that I always recommend is the establishment of work sessions. And so you've got your traditional public meetings, and that's usually where you always allow public comment, and the public comes, and that's now where they can engage with you. And a work session is really, it's still a public meeting, so anybody can come and watch, but they're not participating. There's no comment, there's no opportunity for them to ask questions, there's nothing for them to do. And a lot of times I'll see they even take a different location. So in my city council experience, when I worked for my council, our city council meetings were always in council chambers, so it was very formal, right? All the councilors sat up at the dais, staff had its own chair, and it was much more formal. And when we did our work sessions, we actually were still in council chambers, but we pulled a bunch of tables together and everybody kind of sat round robin, like at a circle or at the table. And it was much more informal. We even had it where people brought their lunches. We always did ours from 11:30 to 1:30, so it happened over a 2-hour lunch hour, and people brought their own brown bags. And we were still talking about city business, right? So we had it publicly noticed, but it was just the council interacting with staff on major issues, and they were talking about the issues that mattered, working through some nuances, answering questions, but it was made more informal. By the way we sat, by the fact that we were eating, the time of day, people were more formal in their dress. And it takes a while to get used to that, to be honest, because you still feel like, oh, it's a public meeting, there could be somebody watching me. But I would say once we instituted, after about 5 or 6 months, it got to what you're describing is lacking. It allowed people to build those professional relationships, to work through those types of discussions and not have the same level of pressure as you would from a council meeting. And that's what I would encourage you to consider doing. Jamie, do you have anything else that you would suggest?
No, I think the work session idea is a really great way to, I think a lot of struggles with the public meetings law and serial meetings is that as elected officials, you want to just get the work done. Like, why can't we just have this whole conversation by email? Why can't we just, this is so prohibiting us from just getting the job done. And so the work session idea is that you remove that public comment part. And, again, of course, the public is still welcome to sit, in the back and watch, but it really allows the work to get done and the discussions that need to occur between council members and staff and whatnot without having to be so formal. So it's a great alternative, kind of.
Okay. Next question. Can a city manager conduct a serial meeting of council members?
Ooh, that's a great question. So I don't necessarily know that I like the way it's worded, but there is, it's a possibility. So there is a theory, and I agree with it legally. So if you remember that the public meeting law violation for a serial meeting is the governing body needs, right? So you had a quorum of governing body members who all met separately in a series of different meetings. Well, the city manager is not part of your governing body, so they're not subject to that. So the city manager could talk individually to each member of the team, not share what they're all saying, and not necessarily create a serial meeting. And so I've seen this happen a lot when you've got a close issue where you've got an ordinance and the whole council is honestly looking for a solution, but we're just not quite finding that right middle ground. And so you've got the city manager or the city attorney who's just trying to figure out where everybody really is and can they help you craft an amendment or a compromise. And I think technically under the law, because they're not a member of your governing body, that is correct. Jamie and I have talked about this before. We're always careful to suggest it as a go-to option. We'd rather you discuss it with your city attorney. And the reason I say that is if you were ever so inclined or bored or, I don't know, wanted to actually read the decisions coming out of the courts about serial meetings, what stands out to both Jamie and I is how emphatic the court was about not doing workarounds, in a sense that they really wanted the public discussions and the public debates to happen in public. So I think that it's perfectly fine the city manager is not part of the governing body. It should not be a serial meeting violation. I'm also always cautious to say absolutely go forward and do it, because I could see some city being sued on that issue at some point, and that's why I think as a city you should talk with your city manager and your city attorney and weigh your individual city's risk reward to see if that's something you want to do. But it's a great question, and it's one that I know a lot of cities have thought about using and might be using themselves.
Okay. Next question. How does serial meeting apply to a mayor who is not a council member?
So another great question. As long as the mayor is actually part of the city council, and to the best of my knowledge, most mayors in Oregon are all still members of the council, they count towards your quorum. So they're going to be just as part of the serial meeting conversation as any other councilor. So unless your city specifically says that the mayor is not a member of council and not counted towards quorum, the mayor is going to count towards that serial meeting issue you've got to worry about.
Okay, next question. What should a city council member do if an executive session for city manager turns into an attack with a discussion of another city council member?
So I think that's one, if you're at a point where you feel like an executive session is no longer on topic, then you need to raise that in the meeting and say, I just want to clarify and make sure that we're still on point for what we suggested the executive session would be. And it depends on what you're talking about. You know, I mean, if the subject of the executive session, let's say, was to do, let's say, a personnel evaluation of a city manager, and in the context of evaluating that city manager, there becomes some disagreement between, like, part of the performance evaluation is their relationship with a council member, it could be reasonable that there could be some back and forth, and that could still probably be related to the evaluation. So it's a pretty specific question. What I would always suggest is, if you feel like you're straying from what you're supposed to do, kind of raise your hand and say, hey guys, I just want to do a quick check. It's my understanding this is what we're here to discuss for the executive session. Are we all comfortable that we're still actually within the bounds of that? If not, we need to stop talking about it, and we'll have to discuss it at a public meeting or at a separately noticed executive session for a reason that qualifies there. What do you think, Jamie?
Yeah, I think counselors need to be aware that a lot of times it's really easy to go and stray from the topic of the executive session. I know personally, which you've probably already noticed today, I get on tangents and I get distracted sometimes because I talk about a related issue. And that can so easily happen in executive session inadvertently. And it's not purposeful most of the times. I've found it's truly an accident. And so it's important to say, hey, I think we're getting off topic. Let's all just do a check here to see where we're at. And you know, if something inadvertently got discussed during executive session, then when you open back up to the public meeting portion, then just be forthcoming and be honest about it. But I think everyone's just trying to do their best, and I think most of the times when things happen that it's truly inadvertent. I'm trying to think on the cup is half full and not empty kind of motto, but it happens. It's easy to stray, and I think it's really important to have that hands up, just checking, and having grace.
Okay, the next is a two-part question, so I will ask it in two parts for you.
Thank you.
Is it correct that the council may discuss in executive session that the information discussed in session should not be deemed confidential and should be made available to the public, and then a vote occurs in regular session to make the information from executive session public?
So I don't know if the answer is it correct? So if you're having a meeting in executive session, the premise is that there's confidential information in there or information you're not legally required to share with the public. If you decide that you want to share that information, then yes, the full council should do that in a public meeting through a vote. Because remember, you're also, the executive session protects the city, and like you're doing the city business. So you don't want to just have one counselor saying, I've decided I want to make the information public. You want that decision to be made by the council. But I would say that if you know going into an executive session that all of the information contained therein is going to be released to the public, I would want you to have a conversation with your city attorney and city manager about why you're holding an executive session to begin with. If the point is you're going to discuss everything in executive session privately and then make it all public, I think from a practical standpoint, you would probably want to have a conversation about why you're going into executive session to begin with.
Okay, here's the second part. What is the potential penalty to a counselor revealing executive session information to a reporter?
So there's nothing necessarily in state law. So there's not even any, like a penalty in state law if a reporter who's in an executive session releases information. There's not particularly a state penalty. What I would say is I've seen some council rules of procedure, not even their charter or their ordinances, but their rules of procedure outline expectations for executive session and what happens if a counselor were to breach the executive session privilege, in fact, share information. Sometimes it's a censure. Some city things have things like loss of travel privileges or you're removed from committee appointments, but those are mostly going to be established at your local rules of procedure. There's not any state penalty per se. It's kind of the honor system.
Okay. Is there a way to remove a member of council or commission from their seat in a specific meeting and or permanently?
Oh, this one's interesting. So maybe. So the first and obvious way that an elected official can be removed from office is through a recall. And so that's essentially done by the public, and it's a separate election, and that can happen. That's the easiest, cleanest, most assured legal way to remove an elected official from office. For those of you that have never done it, probably because you're new, I would encourage you, regardless of what you've learned here today, to read your charter. And in almost every charter that I've read, in fact, every charter that I have read, although I've not read all 241 in Oregon, probably between Jamie and I we're pretty close to having read all 241, most of them will have what they call a vacancy provision. in the elected officials, and you'll see common ones. So if an elected official dies, if they move outside of the jurisdiction, if they no longer have the qualifications to hold office, they essentially vacate their seat. And then some charters go so far as to say things like, if a counselor has been absent from a meeting without permission from the council for 3 times, or they've been living outside of the jurisdiction for 6 months, the council on its own motion can essentially declare the seat void, that there's vacant, that there's nobody there. I have not ever seen one of those charter provisions where essentially the council is saying you're declaring this seat vacant because you no longer comply with the charter. I've not ever seen one of those occur. There's been some interesting discussions that I've been a part of with other municipal attorneys who we think that that's probably permissible, that probably would withstand scrutiny. But the general practice is I think most lawyers would probably feel most comfortable if an elected official was removed from office via recall, because that we know for a fact, just from constitutional and case law decisions, that is in fact the truly way to do it. I've not yet seen, and Jamie, I would ask if you would, I've never seen a provision where somebody could be removed, let's say for censure, like usually a censure is just a public shaming, maybe a couple losses of committee appointments. I've never seen it result in where the council can actually just declare the seat vacant because a counselor has failed to do something. Have you?
No, very rarely. And what I've seen is that when you have like the one counselor who potentially could be someone who a council would want to remove, when it gets to that point, I think a lot of times you see the counselor resign. But it's very difficult to remove council members just because there's a difference of opinion or other issues outside of not showing up to meetings or moving out of the jurisdiction. It's pretty rare. I've never seen it.
Yeah, and if you think about it realistically, we talked in the very opening session about roles and responsibilities, about you're beginning as a group and you want to form a team. And Jamie and I work with quite a few councils who are in somewhat of a distress and they need some help kind of working on those team building and finding that common ground. And so it's difficult, right? If you have 1 or 2 counselors and you're like, they're not really coming together and they're not part of the team. And to suggest that the council should be able to kick them off, while that might be an initial gut reaction, wow, we would be a much more effective body if we could do that, you have to go back to the very, very basic premise. We work for and we represent the citizens. And the citizens elected this person into the position, and that was the choice they made. And as elected officials, we need to honor that choice, even if it's not a choice we ourselves would have made. So that's why it's really hard and kind of limited a capacity to remove somebody from elected office, because we're putting people into positions of power to kind of control significant amounts of our lives. And you kind of want to leave that authority to have them no longer with that power to the people who put them there. In other words, the citizens.
Okay, next question. Is the council president acting in the mayor's absence allowed to remove a city council member from the meeting?
So that sounds like a really specific provision somewhere in your city, because most of the time, I've never even had anybody ask me if the mayor can remove a counselor from a meeting, to be perfectly honest. You're going to want to look at your council rules of procedure, and if you have a charter provision on it, but it would seem rare to me, it's probably going to be in your council rules of procedure about whether or not counselors can be removed. I don't know of any council rule that I have ever seen where somebody could be removed from attending a city council meeting if they were an elected official. It would have to be a unique local rule, and you'd want to talk about that rule with your city attorney.
So I see that someone on the phone maybe unmuted their line ending in 2418, and so I just want to see if you have a question, you can go ahead and ask it. Okay. I don't hear anything, so I will go ahead and move on. Okay. Can council and mayor have an executive meeting without the city manager or city attorney?
Technically, yes. So when you have an executive session, the governing body gets to decide who they do or do not want to attend the meeting. I would personally, as a former staff person and former city attorney, get a little nervous if we're talking about not having both of those people at the executive session. The reason being is you as elected officials, and this is my opinion, you can disagree with me, please feel free to do, people do it all the time. I think as elected officials, you need to understand the rules you're required to follow. So you should understand executive sessions, when you can or cannot have them. But I don't think that you're supposed to be as nuanced in them as your city manager and your city attorneys are. That's why you have professional staff. And so while there's nothing in state law that says you have to let the city manager into your executive session or you have to let the city attorney into your executive session, I would say best practices is that at least one of your staff persons should be there to help make sure that all the notice requirements, all the processes involved in an executive session are there. And as Jamie pointed out, it's super common for people to kind of go off on tangents, and it's natural, it's normal. And it is kind of nice to have that staff person in there, whether it's your city manager or your city attorney, kind of politely and respectfully kind of bringing everybody back. Nope, we're getting a little bit outside of the lane of what we can do. So I would always encourage people to at least have one, if not the, like, if you're not gonna have both, at least consider having one in there. And if you've decided that that's not possible, then I would really recommend that you have a strong conversation with your city attorney and understand what the risks are in not having a staff person there, and have them outline with you specifically the processes you need to follow so that you can in fact make sure that you're getting to all of those nuances that you usually rely on your staff to understand. Would you agree with that, Jamie?
Yeah, and I think it's important to remember some of the minor logistical things that need to be taken care of during a public meeting. So even like who's going to take minutes, who's going to be in charge of recording if you're not taking written minutes. There's a lot of things that, so if you're not going to have your city manager, are you going to have another staff person doing those type of activities? So even little things like that, it would be important to consider.
It's a good question.
Okay, so really quickly, I'm sorry. So the person whose phone line is unmuted. If you could mute it, it sounds like they're getting feedback and your number ends in 2418. I'm sorry, I'm seeing those messages right now that was distracting in the background, so I apologize for not seeing that earlier. Okay, looks like they were muted. Thank you.
Are we good on time still, Lisa?
So we're at 2:20 and I think we just have a few more left. So I think we're okay.
Okay.
I just need to get back to, where we were. So next question, there's two that are similar, so I'm just gonna combine these two. So what is a typical timeline or best practices for a city manager to get packets to council before a meeting?
That's a great question, and it's really going to depend on what works well for you as a city. So I've seen as long as 10 days, I've seen 7 days, and I've seen 5 days. I would say 7 and 5 are probably what I would, if I was going to go out on a limb and you made me put money on it, I would say 5 to 7 is probably the most common. But I've seen as long as 10, and I've seen as short as 3. So it really depends on what your city expectations are. What I typically see is those usually are required in the council rules of procedure. So if you follow best practices, and I'm not going to say that my city ever did, which was my fault because I didn't always require it, is that you should be reviewing those rules of procedure every 2 or 3 years and have a conversation if it's no longer working. So if it's 3 days now and you just don't feel like you have enough time to really review something, feel free to talk with your council about 5. But if you were telling me anywhere between 3 to 10, I would say that was within a normal range from my perspective.
Okay, next question. What can a council member do if they're being bullied or disrespected by another council member? Confront it, let it go, report it, and what is the process for reporting discrimination from another council member, mayor, or city manager?
Ooh, so that's a tough one. So whenever you have any type of conflict, whether it's minor or it is rising to the level of some type of discrimination or harassment, I think if you can try and address it directly with the person who's doing it to you, or who you're experiencing that conflict with, is the best way. Some of my tips when I was dealing with counselors and in some of the work we've done in mediation or facilitation is to make sure that when you have that initial conversation, that you're in the right headspace. And by that I mean, if you're really heated and upset in the moment, or you're really sad at the moment, probably not the best time to be having a serious or calm conversation. So wait until you're in the right headspace and try and address it with them personally. If that's not working, what I have generally found is, particularly if your city council already has rules of procedure, there's generally a code of conduct within there that talks about decorum, professionalism, how we treat each other, and how we interact with each other. And so if those rules and those group norms that you've agreed to are being violated, then I would probably have a conversation first with your mayor as the presiding officer and say, look, it's my opinion that we are not following these established procedures and norms. Here are my examples. I would like your help in making sure that we stick to these agreed upon rules since you are the parliamentarian, and see if that can start working on it and kind of asking the rest of the council to participate in making sure that those group norms are happened. If that's not working, then I would have a conversation with the city manager and see what suggestions they come out to play with. What I think is key, and it's not necessarily part of the question you asked, but I do think this is a key principle that's really hard. I think when you establish rules of procedure, most, if not all of them that I've seen, is that the mayor is the parliamentarian, right? That's the person we expect to keep us in line. And as Jamie and I have said repeatedly, not everybody's going to be perfect every time. Not even the mayors, right? They've got a lot of balls up in the air in the middle of a meeting. And so the rest of the council should try and help out. So if you see that one counselor has been super disrespectful to a fellow counselor, and for whatever reason, the mayor just hasn't said anything, I think it's perfectly appropriate for you to say, you know, point of order, mayor. Counselor Smith over there just called Counselor Jones a derogatory name. That's not how we have agreed to operate as a council. Our rules specifically prohibit that type of action. I would like to respectfully ask, you know, Counselor Smith to apologize and to refrain from that type of conduct, because that's not how we conduct ourselves as a council. So take ownership yourself as a member of the council so that you are also making sure that you're holding others on that team accountable for the group expectations you've set. Any other thing you would suggest?
And I think you touched upon this in your presentation, but with the rules of procedure, it gets really easy to kind of relax on them and not always follow. Like, I know at the league we have kind of a rule where if you want to be acknowledged at the meeting, you have your little name card and you flip it up to be recognized by the chair. And you know, we do that every time, even though we all get, I would say our board member gets along very well with each other. But you know, when you have, when you stop following that, or you only enforce it during certain times, it makes the person feel like they're being picked on when it might not be on purpose. And so as silly as some of those rules or procedure might seem at the time, it really is important to be consistent and to really follow them every time, so that no one feels like they're being picked on just because a rule is being enforced only at certain times.
Can a council appoint people for upcoming vacancies without public notice?
That would be tricky. So one, you're going to want to start and check your charter provisions to see what the requirements are for appointing people to vacant positions. The second one is, if you go back into my slide when we talked about public notice, remember you have to give notice that's going to reasonably tell people what you're going to do at that meeting. So the agenda is supposed to kind of say the who, what, where, and when. And the what, if you're going to appoint people to vacant council positions, I would say it would behoove you to identify that as an agenda item on your council meeting. That would be a pretty big point to not have on your agenda. What do you think, Jamie?
I think that's totally on point. It's a public process, and even though that seat wasn't elected at that point, it's still a public official, and it should be duly noted.
Great.
Do all work meetings have to be recorded?
No, in fact, your public meetings themselves don't even technically have to be recorded. So what you're required to do is you're required to keep some type of record, and that can even just be written minutes. What I have found historically is that almost every city council that I know of records their council meetings, their official public meetings. So any meeting they had to publicly notice, they typically record. And that's really because, quite frankly, particularly if you have a long meeting, it's helpful for whoever has to type those minutes up to be able to refer back to what has happened as they prepare those minutes. If it's outside of the public meeting context, so it's not a meeting of your council or your planning commission, it's just the city manager meeting with the public works director or the mayor meeting with the police chief, those meetings are under no obligation to be recorded either with an audio or through minutes. That's up to whatever city policy you have established.
All right, next question. Should an executive session on employee evaluations only be for those that the council manages, such as a city attorney, or would all employee evaluations happen in executive session?
So executive sessions, again, those are only applicable to the public body itself, so to a governing body. So if you are a city council and you're not responsible for evaluating, say, the receptionist who works the front desk at City Hall, then there would really be no reason for you to have an executive session for that person. If the city manager, however, is the person who is responsible for evaluating the receptionist, the city manager would traditionally, would be my guess, would just do that one-on-one privately in their own office. If they're doing it this year, they're probably doing it privately via Zoom. But there would be no reason really for the council to get involved in that. There could arguably be a situation where maybe you have an allegation that's pretty extreme and the council felt like they needed to hear some information in executive session about an employee's performance. But generally, remember, the safest thing for the council to get involved in when it comes to employees is to only be involved directly in those matters for the employees you actually supervise. So that should be your city manager, almost always, your city attorney, and then in a few instances, some councils will do police chiefs or also be responsible for recorders. But keep yourself limited to the scope of your actual authority over the employees.
Next question. In order to prevent a serial meeting from happening, you said we should err on the side of caution by discussing city matters in public meetings with public notice. Is this something to do even if only one other council member wants to have that discussion with you? In other words, are you able to have a public meeting discussing a particular topic that doesn't take place during a standing committee without a quorum?
Technically, yes. So let's say you had a 7-member council, so your quorum's going to be 4. And you want to have a conversation. So Joe and Susie are both counselors, and Joe and Susie just want to talk to each other. Technically, under the law, that's perfectly fine because Joe and Susie don't make a quorum. So that doesn't have to be publicly noticed. People don't have to be invited. Joe and Susie can have that conversation in the coffee shop. The caveat I always give is that, remember, when it comes to serial meetings, it doesn't matter that it's just Joe and Susie in that coffee shop. If Susie decides to go and tell a third counselor what you guys talked about and get their input, and then Joe decides to do the same at a later date, you have 4 people. So when you're meeting just two, like those 2 of you together, the question I always ask people to consider is, you're going to have to be 100% convinced that both of you in that one-on-one meeting understand the risks and talking to other people in the council, and that you really are agreeing that this is it, this is where the conversation stops. Because if one of you, so if Joe says, I trust Susie, she's not going to do anything, so it's totally fine for me to go talk to this third counselor, and Susie thinks the same thing, well, Joe promised me he wouldn't say anything to anybody else, so of course I can talk to this fourth counselor. You've inadvertently created a serial meeting. So under the law, technically, that's fine. You can talk with counselors below a quorum. But the tricky part with serial meetings is you really have to trust everybody that one person isn't going to inadvertently bring more counselors into the discussion.
What happens if someone uses hate speech? Can you censure a council member if they use hate speech or a member of the public?
That's a great question, and it's a tricky one. So I'm going to start with the censure one for your council. So censure is typically, in my experience, really limited to what your charter and your council rules of procedure allow. So what you are specifically going to want to do before you think about censuring one of your colleagues on the council is you're going to want to identify if you have the authority to do so. So if you don't see it in your charter, that's not the end of the review. A lot of times it actually comes up in council rules of procedure. And in my experience, when I've reviewed any authority for censure, there's usually specific instances in which you can censure somebody. I'm not sure of any that are specifically directed to hate speech. My guess is that would probably come more in line with saying something unprofessional, not acting in a collaborative fashion, something like that. So you could probably censure for something like that. When you're talking about kind of maybe cutting off a member of the public for saying something with hate speech, it's a gray area. And the reason I say that is I do believe that you should have council rules of procedure when it comes to public comment that say things like, no profanity, we treat people with respect, we encourage decorum and all of that. But you have to remember that some types of profanity and unfortunately some types of speech that some people or all people would consider hate can still be protected by the First Amendment. And you really need to be careful before you tell a member of the public or maybe even a counselor that this isn't something we want you to say, so we're going to cut off your mic or we're going to censor you for it, because you could be imparting their First Amendment rights. So it's not related to hate speech per se, but the court cases at the federal level they're riddled with instances when people have said really offensive things when they've done really offensive things that I think the majority of us would believe are inappropriate, maybe even shock the conscience, so to speak, but they've been protected because it's what that person is conveying as part of their First Amendment rights. So you need to be mindful of it. If you had somebody say something really inappropriate and you thought it was hate speech and you really wanted to take some type of action, what I would suggest is that you sit down with your city attorney and find out what requirements or what authority you have to do something. And even if it's not a formal censure item, I had a council that I worked with back in the Midwest, and we had a similar issue sort of happen. And what we decided was we probably shouldn't censure them. Some of that was based on our Indiana Constitution. But what we actually did was our council decided to pass a resolution essentially saying that we were not supportive of that. It didn't reflect our council, it didn't reflect our community, and that we as a council apologized on behalf for the one counselor who kind of was acting outside of what we considered to be normal, appropriate behavior in a professional setting. And that's the route we kind of chose to take in that instance. Jamie, do you have any thoughts?
The only thing I have to add is really just, honing back in on that the public has an enormous First Amendment right to speak to the council, especially in the area of the country that we live in. And so whenever you're considering taking any action, whether it's against a counselor or a member of the public, please just pull in your city attorney. Because even let's say you have a local rule that says, we can censure for hate speech or whatnot to a fellow counselor, just bring them in and make sure that they're at least aware of it, because it is such a protected right that we have here in Oregon.
That's a good point.
So you might have already covered this, but what is the best way to move forward when it happens to be the elected or appointed official who crosses an acceptable line of behavior when engaging with a citizen providing public comment?
Oh, that's a great question. So in an ideal setting, you've got a mayor who's acting as a parliamentarian who kind of cuts it off and says, sorry, we're not engaging. This is a public comment, not a public dialogue. Or, Counselor X, if I can please remind you that our council rules of procedure require that we speak with everybody using professional words or tone, that would be great. Sometimes that doesn't happen, not because I think that mayors fail to do their job, but sometimes, particularly if you get in this really heated kind of battle and people are saying really unkind, uncomfortable things, sometimes people just freeze. I've seen it happen. I've probably done it myself. And so if you're one of the counselors and you're like, it's gone way off the rails and I can tell that the mayor's like, then make a point of order. Hey, point of order, we have council rules of procedure and it requires us to conduct ourselves in a certain manner. And I'm wondering if we're meeting that rule. I'm wondering if we're really doing that right now. If it goes really haywire, and I hope this never happens to you, but if you're ever interested, you can Google like council meetings gone awry and you can see really bad behavior. One of the things I would suggest, and I had this on my council, we've had a couple of heated issues where people would get a little too amped up, and the general consensus is that what would happen is a counselor would say, I move for a 15-minute recess, somebody would second it, and then they would literally just clear the chamber, and everybody would take a 15-minute recess and try and come back, give everybody a chance to kind of decompress. Do you have any thoughts?
No, it's amazing how much just, a quick even 5-minute recess will really reset the tone of the room. So it's a great resource to use. Just be kind to each other. It's a really tough job.
The other thing, and I think I said this in the video, and I can't express it enough, I think the council meetings with public comment that go the best are the ones where the presiding officer almost has a script written that they give at the start of every public comment. And it's clear on what the expectations are, not just for members of the public, but also for the council. It's kind of, I'm going to remind you at every single meeting what our council rules of public comment are, what our expectations is, and how this works. And if you've got a public comment that you know is going to go really long, so let's say your public comment's usually 15 or 20 minutes, but you've got a really hot button issue and you know that today you're going to be there for an hour and a half or 2 hours. I've also seen some presiding officers make it a point that every 5th or 6th public comment they restate those key rules just so it's constantly fresh, and not just the public's mind, but they're also reminding their fellow colleagues on the dais. These are our rules, these are our expectations, doesn't matter how heated it's going to be, we're going to keep in line with this today. And I think when you have those types of processes in place, you tend to see a lot less of the negative comments and the negative exchanges through public comment. You're almost kind of conditioning people to behave at the standard you expect in that type of formal hearing.
Can you talk about best practices for adding agenda items during a council meeting?
Well, that's a great question, and it's one that can cause some controversy at times. One, I would say that you should have in your council rules of procedure a specific process that outlines how that happens. So for those of you that have council rules of procedure, go back and check. Do you have a specific procedure in place that says how councilors can add agenda items during the meeting or at the meeting? I can tell you that what I usually see when I look at rules of procedure is a requirement essentially that it's not that you can add it to this agenda, it's that it will get added to the next agenda. And the reason I see that a lot when I talk with city managers or staff is so that staff has time to prepare the documentation, the research, and the data that you're going to need to make those decisions, and so that the public has an opportunity to come prepared to make comment and understand on what you're going to do with that agenda item. So you can add agenda items without violating the public meetings law at times, but in terms of best practice, if what the agenda item you're going to add is something that members of the community would care about, you'll tend to see rules of procedure require that to happen at the next meeting. There are some that I've seen where you can just add the agenda at the end and you kind of start the process forward, but it's always contingent on what's in your rules of procedure. So if you have rules, go back and check and see what that is. If you don't have rules of procedure and you're going back to your city tomorrow or next week and thinking about crafting rules of procedure, that would be something I would specifically consider making sure is in your rules. How do we add agenda items during a meeting? Is it even possible? Jamie, you have any thoughts?
No, just make sure you're consistent with your policies. It might be easier to say, oh, it's okay to add this one. It's a non-controversial, really quick issue, which is probably fine to do. But then when someone brings up a more controversial issue and it gets denied to add that to the agenda, it might come off as you're denying it only because you don't like my opinion or where this might go. So with anything, if you have a procedure in place, just make sure you follow it all the time, even when that involves simple, non-controversial issues.
That's a great point.
Next question. What press credentials are needed for entry into an executive session? There are many citizen journalists.
There are. This is a really interesting question, and it's an evolving area of the law. So what I would typically say is that we're still not clear. We don't actually have a court decision on this. We have some guidance from the Oregon Attorney General. They issued an opinion about this, I think related to bloggers, about 2 years ago now. And what I would say is that what I've traditionally seen cities do is what essentially has been decided is you actually have to have a formal process. And so what you will typically see is a council will pass a resolution kind of identifying who the known media or news representatives are. So it'll include like the big ones in the state, right? So if you lived in, Jamie and I live in Salem. So it would probably include the Oregonian, it would include the Statesman Journal. There's probably a couple local little newsletters that we might include in there, the local radio stations and the local television studios. So that's kind of automatically you people are all members of the press. And then there'll usually be a second section to that resolution that says, if you believe that you're press, then what you have to do is submit an application to the city council, and you have to show, that you have this publication, even if it's an online publication where you regularly report on the news, and you put in an application, and then the council will decide whether or not you meet the requirements, and if you do, then you become the press. And if you're interested in this, Jamie and I worked together and we created a sample of what that should look like based on what the Attorney General's advice was. And the league, if you go to our website, there's a resource page, and you can look at guides, FAQs, and stuff. And we have a guide to executive sessions, and one of the appendices in that guide is kind of a model for how to help identify who the press is. So you can kind of take that policy as a starting point to craft something locally.
If there is a direct question for a specific member of the council during public comment, what is the standard operating procedure for that question to be answered?
So it's going to depend on your council's operating norms. I would tell you most city managers and probably city attorneys are going to tell you that you still should not engage in a public dialogue, that should still be a public comment. And what I've seen a lot of cities do my mayor was never a chair of our meetings, it was always our council president. He would always say when there was clearly a pointed question, before he'd call up the next person, he'd say, we're taking note of that question and a member from staff or council will respond to you within the next 2 to 3 days. And I think if you can preface that in your opening remarks, if the chair can say at the beginning of public comment, if you've got questions for us, whether it's for council or staff, please know that we're writing those questions down and either staff or council will be back with you within 2 or 3 days with the information. I'm always leery of saying, yeah, just go ahead and answer that quick question, because in my experience, at least 80% of the time, you're going to end up in a back and forth. And once you do it with one person, everybody who's coming up behind that speaker is going to expect to do the same thing. And that's usually the fastest way to kind of derail a business meeting. So just make it clear that we're taking your comment, we're taking your question, we're writing it down, and this is the approximate time in which you should expect a response.
Can votes be taken during work sessions?
There's not really a reason to. I mean, there's not really a reason that would say that you can't. So when you do a work session, it's still a publicly noticed meeting. The only difference is that there's typically not public comment. The caveat here is if you go back to, I think, early part of this program, what I said is, remember under state law, with the exception of your budget law and like land use, you don't actually have to let the public comment, but your local rules do. And so my concern with you taking a vote at a work session is, what do your local rules say? So if your charter, any provisions of your municipal code, or your rules of procedure grant an opportunity for the public to comment on things before votes are taken, and you don't allow public comment at your work session, you're probably going to run into some trouble with your local governing documents. What I traditionally have seen work sessions be is they are intentionally informal without a vote, so that people feel more able to kind of dialogue with each other more casually. You can kind of gain information and get your facts straight, and then you go into the formal meeting, the council meeting, and that's where you do all of the voting. That would be the more normal practice. It may not be a technical violation of the public meetings law, but it would concern me if you started taking votes without checking your local governing documents, because you're probably going to run into some trouble there. What do you think, Jamie?
Yeah, absolutely, I agree. Under state law, there's not really a huge difference. There's not a difference between a work session or a regular council meeting. They're all just public meetings. And where you get that public comment requirement is usually in local charter provisions or local rules or procedures. So look to those local rules and see what they say about the difference between the two for you.
Can you add a topic later that has already been tabled?
Oh, so you're asking me a question about parliamentary procedure, and when you ask me those questions, I always pull out my Robert's Rules of Order book, which I don't have in front of me. So what I'm going to tell you is I don't know off the top of my head. There's 2 places I would say that we would look. The first is we'd look, your council rules of procedure may actually tell you what the rule is regarding tabling in your community. If not, you're going to want to look at Robert's Rules of Order and see what it says, because it gets pretty complicated of how that works. So I can't give you an answer off the top of my head. What I can do, if it's only one person who is interested in that question, or anybody else, if you want to jump in on the comment and say, me too, I'm interested, we can take down your email address from your registration if we've got your name on your profile, and I can look at Robert's Rules tonight and I can send you an email response to that. But I do not have that parliamentary procedure book memorized. It's just too much. Oh, wait, do you by any chance know?
It just depends on the type of topic. I've actually looked into this. I don't have an actual specific blanket answer, because it really depends on how it was tabled, when it was tabled, so it's going to depend.
What is the recommended lead time for agenda packets to be made available to council?
That's a great question. We've gotten that a couple times during these sessions. It's going to depend again on what your city council expects and what your city staff can do. If you said you actually have to pick what you think the average leave time is in Oregon, I would say 5 to 7 days is what I would say is probably the most common. But anything between 3 to 10 days would not surprise me. I don't think those are outliers either. So I would say 3 to 10 days is probably normal in Oregon. What I would encourage you to do, though, is have a conversation with your staff and your council as a whole. How much time does the council think they need? And then what is the reality of your staff turning that around? If council says they want something in 10 days notice, but your staff is really telling you, we're never going to be able to give you everything shorter than 7, what ends up happening is you're going to probably always end up with packets that don't have all of the information you need, and so you're going to be getting supplemental information over and over again. So somewhere between 3 to 10 is probably normal, but it's going to be up to each individual council to figure out what works best for both council and staff so that everybody gets what they need.
In regards to adding agenda items, what are your thoughts when councilors add resolutions to the agenda without sharing the community research as to why they believe this is important or what data was received that would merit this resolution?
So that's interesting. So I think if you go back, particularly to the first segment, if you watched it where we talked kind of about how you form high-functioning city councils and teamworks, my personal preference would always be is that when we're operating as a real team and unit, we are actually actively sharing all of the information for the basis of our decisions. Because that's how we're going to operate best. That's where we're going to trust everybody. And you could have this really great data and we could all agree that we need this resolution, but I may look at it just a little bit different than Jamie looks at it. So I may want to see something else put in there. So there's nothing legally wrong with that at a state level. And there may not be anything problematic with that from your council rules of procedure. But if we're talking about how we make a group of people a cohesive, high-functioning team, I think you want to try and share as much information for your decisions and for the work product that you create as a whole. What do you think, Jamie?
Yeah, and remember, you individually as a counselor, you have no individual authority except for maybe some very limited specific circumstances. So regardless of what the resolution is about, you still need to convince your other, 3 or 4 or 5, whatever number requires a quorum, to agree with you to pass that resolution. So there isn't much to gain, I don't believe personally, from trying to kind of sneak in a resolution without all the complete information. And I don't think it's fair to have to make a decision without having all the facts in front of you. So again, it's really, what kind of dynamic is that really setting for the council? And I think disclosure is always the best route to take.
If counselor meets with the city manager one-to-one and asks questions about council issues, is that a serial meeting? And to piggyback on that, what if each counselor meets with the mayor one-on-one?
Okay, so the first one is the easy one. No, that's not a serial meeting. So the key starting point with whether or not you have a serial meeting is, remember, the public meetings law only applies to the governing body. So it only applies to members of the city council. So your city manager is not part of the city council. So meeting with your city manager is never going to constitute any type of public meeting because your city manager is not part of the public body. If every counselor, to go to the second question, met with the mayor, probably, because the mayor would have been having a series of conversations with over a quorum of the governing body, and that would equal a potential serial meeting violation. So it's fine to do it with the city manager. In fact, I know quite a few cities have taken the position. So let's say, for example, you're working on a piece of legislation and you don't yet quite have consensus from the council. You're close, but you've got one side that seems to be leaning left and the other side seems to be leaning right. And the city manager wants to figure out, is there a middle ground? Like, is there something that staff can propose that's going to be helpful? If the city manager had a conversation with each counselor individually and didn't share what they were learning with everybody, that's probably not a serial meeting violation because, again, the city manager is not part of the council, and so no member of the council has ever met together. They've just met individually with the city manager. That's not going to be a serial meeting violation. But if you met with the mayor as opposed to the city manager, then that person who's doing all of the meeting is part of the governing body, so you're inherently going to get to that quorum. It can be a little tricky and confusing. What I typically try to tell people, especially if you're a newly elected official, is to have a conversation with your city manager about whether your city has kind of any written or unwritten policies about how to handle those offline communications so you can figure out how to avoid serial meetings. I think I said this in the training video, but just in case. The serial meeting law is relatively new in Oregon, less than 3 years old at this point. And there's still some gray areas in it, and we're still learning how to deal with it. And there's lots of different legal arguments. So there's conservative approaches and less conservative interpretations. Lawyers at the league are always going to take the most conservative approach possible because we represent all Oregon cities. And a lot of our cities don't have in-house counsel or funds to be hiring attorneys if they make a mistake or get sued. So it's possible you could go back and have a conversation with your city attorney and their interpretation is more liberal than mine. That does not mean that as a lawyer I disagree with them. It's just a risk-reward balancing that your city's decided to do, and I always choose to give the most conservative advice possible to make sure I cover all of our cities as best as possible.
Next question is about executive session. Can the council dictate what reporters can and cannot report out from an executive session?
Yes, absolutely you can. In fact, both the league kind of just cribbed it from the state, but the Oregon Attorney General, if you go to their manual on public records and public meetings, in one of their appendices, they actually have a sample script that they suggest that you read at the start of each executive session to specifically put on notice to media what they can or cannot report on. If that's too daunting and you want to go to the league's website, we have a reference library. And in that reference library, there is a guide to executive sessions. It's much smaller than the Attorney General's manual, and we have a model script in there, and we recommend that you read that script at the start of each executive session so that the news media and anybody else who you may have invited to attend understands clearly what they can or cannot report on when they leave the meeting.
Next question. You said we could use executive session to discipline an employee unless the employee requests a public hearing. What about disciplining an elected official?
So typically disciplining an elected official is usually more along the lines of a censure. Some people have done executive sessions in terms of like hearing information about alleged misconduct from an elected official. What I've also seen though is some cities who've chosen to do those in public forums, kind of they are treating employees a little bit differently than their locally elected officials. If that's what you want to do, what I would suggest is that you have a frank conversation with your city attorney about whether you can have an executive session for that instance, and then the pros and cons of not doing so. And you're also going to want to check to see if you have any local rules that come into place. Public employees are given greater protections in some respects than elected officials, because in elected officials you don't have to worry about employment law context, you do with employees. So check with your city manager or city attorney to see if you've got any local rules or policies that are going to govern how you behave in that instance. And I say that because some city charters have specific censure requirements, or council rules of procedure have specific censure requirements. And I've seen some where they require those hearings and some of the investigatory stuff to happen in a public forum. So you're going to want to make sure you pay special attention to your local rules and policies in that type of instance.
Okay, next question. Doesn't Article 1, Section 26 of the Oregon Constitution protect the public's right to instruct their representatives? Doesn't this provision of the Oregon Constitution guarantee the public's right to participate?
So I don't have all of the constitutional provisions memorized, so I don't have the wording in front of me. If what I think you're asking is, do Oregon citizens have the right to participate in all parts of the government structure and process? No, that's not what the courts have said historically. When it comes to the public meetings law and how it's been interpreted, is that it really is a public attendance law, not inherently a public participation law. And there are specific exemptions for executive session. We went kind of through the list of them, and there are public policy reasons for why some of those hearings and discussions happen behind closed doors.
Next question. What about giving more time to a person representing a community group than time given to an individual?
That's great, and it is a common issue that cities face across the time. My council used to have it too. My solution when I was a city attorney is that you then don't have that person come in public comment. So let's say, for example, your community has a standing benefit. So in my community, every year around Halloween, we would have the locals pottery guild would do what's called the soup bowl, and they would make hundreds of thousands of ceramic soup bowls, and then we would all go to the convention center, and you could get 9 or 10 different kinds of soup. It was a big charity thing, and all of the money would go to the food bank. And let's say you wanted to give that group time to talk about the event at your council meeting. Don't make them come to public comment. Make them an actual agenda item for discussion. The same way you would for reading an ordinance, for the council adopting a new contract, you specifically put them on the agenda, because then they're not subject to the public comment rule. So you can give them more time to speak, you can ask them questions, it can be more of a dialogue the same way any other agenda item would be, and leave public comment literally for those public comment moments when you don't know what people are going to say, but you want to give your citizens an opportunity to comment on what you're doing or issues they're having at large in your community.
Next question. What do you advise a counselor respond to a fellow counselor who calls outside a meeting to comment on an item for which they feel they must recuse themselves when the issue is addressed in the formal meeting?
Never had that question before. So I think it's two parts. So generally speaking, I think particularly if you're talking about a new counselor or somebody who's looking for more of a mentor, I think those are good things in the sense that, if you've got somebody who has some concerns about whether they did the right thing or something happened and they're really coming to you in more of a mentor style, as long as you don't end up in the serial meeting context, which seems unlikely in a mentoring situation, I think those are good relationships to have because I think you can learn from each other. If it's possibly, instead of it's somebody complaining or gossiping about something that happened at a council meeting, so it wasn't that they recused themselves, it was that another counselor who's not either one of you should have done something they didn't, I think that can be problematic because remember, you're supposed to work as a team, and when you start having these little sidebar conversations that seem more gossipy or complaining is when I think you start to see fractures develop in teams. So I think what I've been able to do successfully sometimes when I've had issues arise professionally or with my counsels is just a general understanding to say, you know what, if you need to vent, that's fine to a certain extent, but I do not feel comfortable bad-mouthing any other fellow counselors. I don't want to rehash conversations we had at a public meeting. If you think that we still have ongoing issues, then we as a council need to figure out how to discuss that moving forward. Because what you have to be mindful of is that you are going to walk away from a council meeting at some point annoyed. You're gonna walk away from a council meeting at some point having not had your position win the day. And what's important, and when I've heard counselors who do it really well, is they kind of are able to almost compartmentalize and put that aside. And if you go back to the very beginning session we had today about roles and responsibilities, I think you heard two counselors, Counselor Brad Nanke of Salem and Commissioner Amanda Fritz from Portland, tell you that you are going to lose some of your votes. But if you want to keep that team strong, you're going to have to put those aside and move forward. And I think it's really hard to put those aside when you've got sidebar conversations and complaints happening behind closed doors. You can't control what the other person is going to do. You can't control them from calling you and starting the conversation, but you can control how you can respond. And you can say, you know what, I hear that you're frustrated and I hear that you're upset, but this is an issue for the council to discuss, or council has already made this decision, and as a body, I support what the body did. So I'm sorry that you're frustrated, but I can't participate in bad-mouthing or complaining about what the council or a particular counselor did.
Okay, next question is a long one. Council packets are sometimes 500 to 700 pages long for a development, and then the staff presents a consolidated PowerPoint that explains the proposals, but that was not made available to public or planning commission or city council before the meeting. Can we, as councilors, require these PowerPoint given by staff or developers that they be posted 5 days ahead of time?
Short answer, there's nothing in state law that says that you can't. What I always typically recommend is that when it comes to council packets and how and when councilors receive their information, that's for each council to decide. So if you as a council are struggling with those really big packets and you really want the summation before you get to the council meeting, then I think what's appropriate is for your council to have a conversation with your city manager and identify if there's room to kind of build those things into the process, if those can happen in advance. There's nothing in state law that mandates it. There's nothing in state law that prohibits it. It's really going to be up to each council to decide what you do or do not expect to be included in those packets and how soon you get that information. I can say with certainty that there are some councils I know in Oregon who get their packets 3 days in advance, and there are some that get them 10 days in advance. It's really all about what works for your individual community. And I have seen, not necessarily in Oregon, but in prior professional lives where you got your packet in terms of length or detail depending on the topic. So if it was a small packet, 50 pages, you probably were going to get it 3 or 4 days in advance. If it was those big development projects, you might get it a little sooner. Although the tricky part is, I will say with development projects, is if it's a massive project, it's also not uncommon for minor tweaks to be happening as you go. So sometimes the delay in getting information is because we're trying to only give you the information one time. That might also be at play. But talk with your city manager and your council as a whole to figure out what's going to work best for your community.
Next question. If council or the mayor appoints 2 councilors, not a quorum, To study an issue, do the counselors' meetings to perform this task create a public meeting requirement?
Possibly. So what the public meetings law says, remember, is that a governing body is not just the city council. The city council can in effect create it like sub-governing bodies. So if you appoint, so if the governing body says, oh, let's take a big issue now. So affordable housing has been a big issue across the state for a while. So let's say as a council you decide we're going to create a subcommittee to study affordable housing issues in our community, and we want them to report back and give a recommendation to us. If that subcommittee is only 2 people and they don't make a quorum of the council, but that committee that you've created is now going to be responsible for making recommendations to the council, that new subcommittee is its own new governing body subject to the public meetings law. So it will have its own quorum requirements, it will have to give its own public meeting notices, all of that. So when you create a subcommittee or task force or work group that has to give recommendations to the city council, those generally are considered public bodies themselves.
Okay, next is a comment within a question to follow it up, so I'll read the entire thing. A good caution is to make sure counselor-appointed board members that may be taking potential public testimony not roll eyes, smirk, and otherwise express disapproval over what is being said. It affects the public's perception of how the council and the boards are to any public testimony. Someone told me the serial meetings violation only happens if, when talking to Counselor B, I say what Counselor A thinks about it. Is that not true?
So I'm going to agree with the tip about rolling your eyes and making, facial expressions. I've been told I make a lot of facial expressions, so it's hard because those can seem disrespectful. Serial meetings are more than just sharing the information. So it's not just Counselor A talking with B and then Counselor A sharing it with C. Remember, it's that group of, let's say 4 is your quorum. Counselor A and Counselor B talk over the phone on Monday, and then Counselor B and C meet in the grocery store on Wednesday and talk, and then Counselor D and A exchange emails over the 4 topics. So, A never shared with the other 3 what they were saying, but 4 people did all meet in a series of meetings about the same topic. So it's not just the one person plays the worst game of telephone, it's that you have a series of individual meetings that equate to a quorum having occurred behind closed doors.
Okay, we've got about a little over 7 minutes left and 3 questions to go, so let's start with the next question. Can a non-elected committee report to a counselor or city administrator? The council gets reports from council or city administrator. Not quite sure.
I'm not sure I understand the question.
I'm not sure I
that
do
one.
either. Maybe the questioner can clarify that. I'll move on to the next one in the meantime. When a neighborhood association is representing a bunch of neighbors on a development, is it appropriate or possible to give them more time?
So if you're in a land use hearing, typically everybody gets the set time that's allotted in your rules of procedure, and you can't really expand upon that. What I have found that some neighborhood associations have done, I've experienced it with my own councils, is that you kind of collectively agree into what the speech is going to be. So I've seen it essentially be you've got 10 members, and I'm going to take this topic, you take this topic, you take this topic, so you each hit your 3 to 5 minute mark. I've also seen it taken to, I would not say extreme, but an even higher level where the neighborhood association, wrote one long 10-minute script, and then person A read it until somebody said time, and then B came up and picked right up where they left off. But generally speaking, when you've got those rules that say this is how much time you get as a collective, that's the time that you get, and you can't expand it just because you like this group or you want to make sure lots of people get there. What I always tell people, the best thing to do as a council is to be really crystal clear about the time restrictions that people are going to have. And that's not necessarily waiting until the meeting. I've seen a lot of really successful cities when they knew they had that huge contentious issue come up and people were going to come out, that they've worked with those key partners. So they've worked with the president of the neighborhood association to say, you really need to let your people know it's 3 minutes per person, and overall we can only have an hour's worth of testimony tonight, and I'm going to let pro speak and then against speak, pro speak, against speak. So not all your people may be able to talk, and I really need you to help communicate that with them. It helps lessen some of the tension that you'll feel during the actual meeting itself.
Next question. The city charter specifies the quorum is a majority of members on the council. The council is normally 6, so 4 would constitute a quorum. Does that number change to 3 if one of the councilors resigns?
Oh, that is such a hard question for me to answer because there's different opinions on that. what I always tell people is those are one of those instances where you need to contact your city attorney. And I don't say that loosely, because I know a lot of you out there, calling your city attorney means spending a couple hundred, sometimes thousands of dollars. What I have found with those interesting charter provisions is you're probably going to have to make an interpretation as to what that means in your charter. Is quorum based on the total number of counselors that can be had, or the total number of seated counselors at any given moment? And I can tell you that depending on how your charter is written in other areas, so other provisions language is going to impact how that interpretation is worked. So since being at the league, I've probably talked with 5 or 6 different city attorneys who are trying to interpret a charter provision just like what you described. And because of the way other provisions in their charter have read, they've reached different conclusions. So if you've got that issue in your charter, I have 2 suggestions for you. The first is that you talk with the city attorney and see if they can give you an interpretation that's going to work. And if so, your council should make a formal interpretation based on that advice. The second thing I would tell you is that if at any point you feel like it's time to review or amend your charter, that's one of the provisions I always recommend that you seek clarification from when you amend the charter, so that it's clear that quorum is for, the number of currently held seats or something like that. But talk with your city attorney, because they're going to have to review your entire charter in order to help you get an interpretation as to what that provision actually means.
Okay, we're about 3 minutes left, and there's still a number of questions. I did get some clarification, I believe, on the one.
Okay.
Can a non-elected committee report to a counselor or city administrator?
Yeah, that's not uncommon. So what I've seen, for example, is when you've got a big community issue. So, we want to, for example, let's say we're going to redesign one of our key parks. And so you've got a non-elected committee of citizens who are giving their input on park stuff, and they're reporting, say, to the parks director instead of the full council, or they're reporting their findings to a counselor who has a particular interest in parks. That's totally fine. It just depends on how your city creates the committee and the reporting structure at play. That's really a local decision for you guys to make.
Okay, we are at the 2-minute mark. We've still got 3 questions in the queue.
Okay.
I can try one more to fit one more in?
Let's do one more, and if you have questions that we haven't get answered to, please know that Denise is sending them to me electronically, and as I said in a prior session, over the next 3 business days, I will look at all of those questions, put together answers, and I will email them to everybody who registered to attend today's class, so everybody heard the same information.
Okay. Last question then. How do you know if a serial meeting is happening? Does this mean we should not chat with other counselors about city business out of the formal meeting?
I love this question because it goes to the heart of why I take a conservative approach. You don't know if a serial meeting is happening. You really don't. And when we're in person, what I always like to tell people is that, you're going to run into that situation where, it's Patty and Denise, and we're only 2 people, so we don't make a quorum. And so we're talking about it because it's fine. And I look at Denise and I'm like, Denise promises. Denise says, Patty, I'm not going to tell anybody. It's just going to stay between you and I. We went to that elected centrals training and they freaked us all out about serial meetings, so I'm not going to say anything. So I'm sitting here talking to Counselor C one day, and I'm like, Denise is trustworthy. Denise is totally not going to tell anybody. So I can totally tell Denise. I can totally tell Counselor C because I know Denise isn't going to tell anybody, and this other person doesn't make a quorum. Well, Denise trusted me that I wasn't going to tell anybody, so she thought the same thing I did, so then she talked with the 4th person and we hit a quorum and now we're in trouble. The reality is serial meetings, in my opinion, almost always happen by accident. And they happen because we trusted each other not to talk about it, or we just quite frankly didn't know somebody was talking to somebody else when they told us they wouldn't. And so when I always say, I think you need to talk about the city business in a public meeting, it's primarily to avoid that unintentional serial meeting because they happen completely by accident, in my opinion. But the second reason I always tell people that they should do their public discussions they should do their city business discussions in a public meeting is because if you subscribe to the intent behind the public meetings law, which kind of boiled down at its base core, is that you talk about the public business in public, that we owe it to our constituents to be transparent. And that when you have a discussion, even with one other counselor, behind closed doors, and you're creating a meeting of the minds, you're convincing each other of your position, you're solidifying your support, you're really not being wholly transparent about the decision-making process that you engaged in as a collective body, because some of that happened outside. So yes, you have to worry about the serial meetings law, and that's why I tell you to make sure you talk in a publicly noticed meeting. But I also think if you're somebody who believes in the intent behind that law and that transparency and people seeing the process in its entirety work out, then you should be doing that even if this whole serial meetings law issue wasn't something to be concerned about.
Pertaining to serial meetings, when a mayor is preparing to make council assignments, are there limitations for a councilor approaching the mayor privately to discuss his or her assignment preferences when it's possible other councilors may have a similar discussion and reaching a quorum? Recognizing that a similar discussion conducted electronically would trigger public records retention requirements, are there further considerations with this type of communication?
Yes, so it's good that that raised a warning flag for you. If you have a quorum of the member of your council who starts talking to you about committee appointments, and it's probably all related, and you could end up with an unintentional serial meeting pretty quickly. And it doesn't matter if they're communicating with you via email, they're doing it in person, or they're doing it over the phone, or some other type of technology that I don't understand yet. The issue is, did you have separate conversations essentially over the same topic with a quorum of your council? So again, I think I said it in the video, what I always recommend is that if you're going to discuss city business, you do it in a publicly noticed meeting, not necessarily those sidebars. So what I would say I've seen some councils do, not all, again, it's up to you to decide how your council runs, being mindful of state's public meeting law, is I've seen some councils who've essentially almost kind of have like a preference or an application process for councilors who want to be appointed to committees. They submit them their public records and the mayor kind of reviews them and makes decisions without having those kind of sidebar conversations. Sometimes what they essentially do is, at the first meeting of the year, they kind of walk through, here's the committees, who's interested in it, tell me why. You kind of have it's all going on at a public meeting, and then the mayor makes a decision either at that meeting or after consulting with the city manager at a later date. There's different ways to do it, but generally speaking, it is correct that you had a red flag that if you talk with a quorum of your councilors all about committee appointments, you're probably going to have a potential serial meeting violation.
We have a question regarding quorum. If a councilor leaves mid-meeting, resulting in the loss of a quorum, is it legally required that the presiding officer adjourn the meeting immediately? And also, for a study session, do you need a quorum to meet?
So most of your city charters are going to require you to have a quorum to conduct official business. So in the case of a council meeting, if somebody leaves and you lose a quorum and you have business that you have to complete, whether it's you have to adopt an ordinance, adopt a budget, you've got to make recommendations about which contracts to enter into. If you made any of those actions without a quorum present, my guess is your charter is going to say that those actions were not lawful, and you're going to probably have to redo them at a different public meeting when you have a quorum. Work sessions are a little different. They should always be publicly noticed, but if you're not making a decision and you're just gathering information, you can continue to gather information if you have less than a quorum. You probably just can't take any official action. What I would suggest is that you take a look at the charter and maybe even your council rules of procedure, because sometimes quorum's expanded upon in your council rules of procedure. And if you've got questions about how those should be interpreted, start with your city manager, and if needed, talk with your city attorney as well. But generally speaking, your charter is probably going to say you can't conduct business unless you have a quorum. So you're probably not going to be able to take any official action. And if you need to take action, you're probably going to just have to recess the meeting and come back later when you can have a quorum present.
That is all the questions so far.
Okay, so in case anybody wants to take a few minutes to kind of think up some questions and tools, what I always like to do when we talk about public meetings, and I have a few seconds for my soapbox, is the number one thing that I think is going to make all of your lives better is really your council rules of procedure. If you're a newly elected official, my tip for this session would be to reach out to your city manager or administrator and ask for a copy of your council's rules of procedure. Take a look at them, read them. If you've got questions about stuff, go ahead and make sure that you schedule a meeting to talk about them with your city administrator. If your council does not yet have rules of procedure, then I would at some point consider at a council meeting talking with your fellow councilors about what that would look like. The league has model rules of council procedures. So we've designed them specifically for our smaller city jurisdictions. I'm happy to share those with you if you're looking for a starting point. Also happy to give you copies of rules of procedure used by other cities across the state. We can even try and tailor them to your specific region or population size if you want something that's more comparable to your particular city. In addition to making sure you read them before you take office, I think it's super important for those of you who have been in office for a long time. This should be one of those things you take out and read once a year. I think you should be reviewing them every 2 or 3 years to make sure they're still working for you. It's my experience that with council rules of procedure, we tend to establish a process, we follow them for a year or two, and then we start deviating from them because it starts working better. The deviation works better for us than the rule. If that's what's happening, then amend your rules. Don't just deviate from them. Make sure you take a look and amend and update those rules of procedure. I think having solid rules of procedure and understanding them is the easiest, most efficient way to make sure that your meetings are run successfully. And it also helps lessen any conflict that might arise during those meetings. Any questions, Julie, that have come in?
Yes, one more. Could you repeat the name of the Supreme Court opinion about serial meetings? Was it the Boise opinion?
No, so the Supreme Court one is, I don't have the full name, it's TriMet, it's the TriMet decision. I don't think it's on the slide anymore. What I will do is I'll have Julie send this question to me, and I will actually send everybody who registered today a copy of the opinion directly, so you can take a look at it and read it at your leisure.
All right. Did get a few more. How often are rules of procedures updated or modified? We have 6 or 7 new counselors and wondering how much they may shift these rules.
So I don't think they're updated all the time. My experience would be, and this is not based on like data so much as just observing other cities and from when I used to practice myself, is that we would take a look at them as a council every year and see if anybody had any glaring issues that needed to be addressed. But we probably weren't actually adding updates, but maybe every 2 or 3 years. And so I would say shoot for the 2 to 3 year mark, because the reality is once you get into those council rules or procedures, there's probably not a whole lot of room to change. There's just kind of minor tweaks that happen. But I would say take a look at them every year and see if you've got glaring holes. And then maybe every 2 or 3 years do more of a kind of a comprehensive review and see if there's any editing that's needed.
Is it permissible for council to discuss an item in public prior to a motion and second being made?
That's going to depend on the rules of procedure that your council chooses to follow. So a lot of your cities will say that you default to Robert's Rules of Procedure unless you have other rules in play. I think Robert's Rules is great for really large bodies. I don't know that it's particularly useful for small governing bodies like most city councils. So what we typically recommend at the league is that you kind of create your own rules of procedure based on how your organization is going to function best. Some of it will mirror Robert's Rules, but if you looked at like the current edition of Robert's Rules, it's about this thick. I mean, it's a pretty thick document. What we've also suggested is that a lot of those rules of procedure, they'll spell everything out and then they'll say, if something's not covered here, then we default to Robert's Rules. There's actually a portion in Robert's Rules, and it's in the table of contents, and essentially they create a separate internal policy for small governing bodies. And so what I've started to see cities do is when they say, okay, these rules apply, and if we don't cover something, we default to Roberts. They are, instead of defaulting to the full Roberts Rules, they default only to that part that's applicable to small governing bodies. So it's a long way of saying, take a look at your rules of procedure. If you don't have any, you're probably defaulting to Robert and look at theirs. But the key thing from my perspective is if you end up having to default to Robert's Rules, almost all local rules of procedure are going to say that you shouldn't use Roberts as kind of a sledgehammer. And by that I mean, if you start reading Robert's Rules of Procedure, it's incredibly specific. I serve as a parliamentarian for my organization, and it's so dense and cumbersome that a lot of times I actually have to open it up and take a look at it and research it, and sometimes there can be quite conflicting or seemingly conflicting provisions in there. So you don't ever want to use the rules as kind of a tool to like, haha, gotcha, I'm not going to let you talk. Typically what I've seen in terms of your specific question is most councils aren't that formal, so most councils will start having a discussion and then somebody will make a motion or a second and then they'll go back and ask if there's any more comments. There's not really a right way or a wrong way. It's really what works best for your council.
Question of, just to be clear, as mayor-elect, if I'm approached by councilors on being council president, am I subject to the public meeting rules?
You are not, as an elect coming in, because you're not subject to public meeting law until such time as you are actually sworn into office. So you don't have to personally worry about it yourself. If they're already sitting councilors, they would want to be mindful that their conversations don't result in a quorum of the current council having a discussion about the same matter.
Is the notice for a public meeting or executive session needing to be in the newspaper or posted somewhere else?
You don't actually have to post them in the newspaper. There could be some certain instances where you have to post in newspapers when you're talking about like public contracts and maybe a few land use stuff. But generally speaking, your city council meetings, you have to post them in a way that's reasonably likely to cause notice for people. So you can post them on your website. Some city councils will post them on community bulletin boards, in libraries. I know of one city that's a very, very tiny city. It's our smallest city, Greenhorn. They actually post, they only have 2 or 3 meetings a year. They post their notice on a tree, which I thought was really cute. We got a picture of that one time. But generally speaking, it doesn't have to be in a newspaper. It just has to be something that you can give notice. People are reasonably likely to see. And then always remember the second part. You also have to give notice to interested persons. So people, if you know if somebody is specifically likely to be interested in it, you should give them notice as well. I always, as a rule of thumb, so for example, my board of directors is a governing body. So whenever my bylaws subcommittee meets, that committee is talking about maybe changing the bylaws, which governs our board of directors. I also always give notice specifically to my board as well, because they probably have an inherent interest in what that committee's doing. But it doesn't necessarily have to be a newspaper.
And just to add one thing, Patty, your charter might have an additional requirement. So your charter might say you need to publicize it in the newspaper, so just double check that. But by state law, everything Patty said, there's really not a specific place.
Okay, the next question. As a practice, we have public comments for non-agenda items limited to 3 minutes at the beginning of the meeting. We don't have non-action agenda items. All the business items are hearings or actions for decisions by the council. For informational presentations, we place them on the agenda under the public comment section. An example would be by Tree City USA recognition that last 5 minutes or so would be listed on the agenda under public comments as a presentation with a time listed. Since we list them on the agenda under the public comments, does that mean we would have to give everyone who speaks under public comment 5 minutes?
That's a really specific question. So I think it could be interpreted either way. So generally speaking, if it were me, I would say best practice is just leave public comment to only public comment. And so like the Tree City USA, put them as an additional agenda item somewhere else. That would make the line and the distinction more clear. That said, it sounds like when you have your public comment and you put Tree, City USA underneath it with its 5 minutes, you are trying to do just that, if not actually doing it. So I think there's an argument either way. If it were me, to be the safest course action, I would probably completely separate those things and just have them be their standalone agenda items.
Yeah, I agree with that.
Okay, next question. How do work sessions compare to common council meetings and executive sessions? Do they require similar notice?
Yes, they require the exact same type of notice. The only difference typically in terms of the public meetings law is that, and it's not even necessarily the public meetings law, it's usually your local rules of procedure, is that there's no place for public comment. I have seen some city councils try and do work sessions. They try to make them even appear more informally. That's what my council used to do. So instead of having the meeting in council chambers, we would have our work sessions in a conference room. And they, in a council meeting, my counselors were dressed a little bit more business professionally, and our work sessions, they tended, honestly, my work sessions always happened over the lunch hour. They were between 11:30 and 1:30. And so my counselors a lot of times were more casually dressed. They would brown bag lunch. And so it was a much more informal setting, and it was really meant more for the council to work together and work with staff, usually on big pending issues. So, we had a massive ordinance that we're going to do an update to our development code. So we're kind of getting their feedback, comments, concerns that they want. There's not an opportunity for public comment, but you do still have to publicly notice them. So the same type of notice has to be issued. There still needs to be minutes. Those things happen. The other big difference typically is in work sessions, there are no decisions being made. They're usually an information gathering or an educational component. The decisions themselves are usually restricted to only happening at your official public council meetings.
Okay, next question. When and under what circumstances can you cancel a public meeting?
So there's no rule per se, you just have to give notice if you're going to cancel it. Best practices would suggest as soon as you know. So I mean, there's probably going to be instances, this has happened to me a couple times, where you actually have to cancel a meeting because you just didn't get a quorum, which was not anticipated, right? But you can't do any business, so you're literally canceling it on the spot. There's been a couple instances where I've been an attorney working with the council where we knew in advance, we knew 3 days in advance we weren't going to have a quorum, and then we would notify everybody that was canceled. So every place we posted our public notice of the meeting, we would then post notice of it being canceled. What I have also suggested before in the past with cities, if you're canceling something and you knew you were going to have a contingent of people come out, so you knew there was a neighborhood association that was particularly interested in the issue, or let's say, for example, a representative from your Chamber of Commerce comes to every single council meeting, even if there's not anything necessarily on the agenda, they just do it as a matter of practice. As a matter of courtesy and respect, I would have then said, okay, let's tell the president of the neighborhood association, let's call the Chamber of Commerce and let them know we have to cancel it. There's nothing that says you're required inherently to do that. But if you don't have a quorum, then you can't hold the meeting. Or if you decide that you just don't need one because you don't have any stuff going on, you can do that. And then you also want to, Jamie kind of mentioned this earlier, check your local rules. So check your charter to see if there's any specific requirements there, and check your council rules of procedure to see if you have any there. The only other thing I would say, and only because this became an issue one time, is make sure you tell all of your councilors that it's canceled. So I once had to work with a city who they canceled and they forgot to tell 2 councilors. That's probably not a good idea. So make sure you tell them.
Okay, because of a recall and several sudden resignations, the 6-person council is reduced to only 2. The 2 councilors conspire to appoint the citizen they wish to have on the council. Does this fall under serial communication, and who regulates serial communications?
Okay, so I'm going to try, I think we're talking about something really specific. So what I would say is there's a couple issues with the question. So when you have vacant seats on your council, the question of what constitutes a quorum is sometimes up in the air. So you're going to want to look at your charter. The way some charters are written, those vacant seats don't count for purposes of a quorum. So if you only had 2 people, then unfortunately a quorum's still 2, because that's how many there are. There's other instances, quite frankly, where those vacant seats still count towards a quorum. So your quorum requirement is actually 4, which means the remaining councilors can't do any work, which is problematic. So you want to start with the charter to figure out what an actual quorum is when you have a vacant seat. As to conspiring in terms of having a serial meeting that's not publicly noticed, who enforces it? So if you or any member of the public suspects that somehow there's been a serial meeting violation, then you can make a complaint with the Oregon Government Ethics Commission. What I would suggest is that I personally, and this is not true I'm sure for everybody, but I personally believe that most serial meetings happen unintentionally. I don't think that even sitting councilors across the state still understand what a serial meeting is and what its impact has and what it means they can or cannot do. So a lot of times I try to come from a place of education instead of enforcement and say, okay, let's talk about what we can or cannot do. Does this person need more training? And let's see if we can prevent it from happening in the future. That said, if you're asking who you would file the complaint with, it would be with the Oregon Government Ethics Commission. Anything you want to add?
No, just, again, it really just depends on your charter too and how to replace those vacant positions. So some charters might say if there's a vacancy, it's going to be by appointment, usually by the mayor with approval of the rest of the council. Again, if there's only 2 people on the council, then that might be a little different. So while it might, again, it's the public perception versus what the actual law is, it might seem a little weird to have only 2 people have a say on who sits on the rest of the council, but that might be what it is depending on the charter. So you might just have to look there.
Yeah.
Okay, so you may have answered this at this point, but I'm going to ask it anyway. So the public meeting question still seems a little gray. Is a committee meeting with 2 members still a quorum because there is 100% of the members present? A council meeting with 6 members but only 2 on the committee?
Maybe. So first, yes, let me acknowledge that a lot of the law is gray. That's probably because it's written by lawyers and we want to keep our jobs. No, I'm just kidding. That's not really true. Maybe a little bit, tiny little bit. Anyway, so the tricky part with public meetings when you're talking about committees. So if you remember a little bit earlier, so when you have subcommittees that the governing body creates. So let's say you've got your 7-member city council, and you know that a quorum is 4 in that instance. But the council has a really complicated issue that they don't understand and they want to study it a little bit more. Let's say, for example, you have an affordable housing issue, and so you really want to figure out how you can create more affordable housing in your community. And so your council creates a subcommittee. Let's say that subcommittee is comprised of 10 people. And of those 10 people, 2 are sitting councilors, some are your plan commission members, some are staff, and then some are just citizens who are interested in it. So it's kind of like this big combination of people, some from councilors to committee members, staff persons, and just citizens. That subcommittee on affordable housing, because it's making recommendations to the full city council, has now become its own separate governing body that's subject to the public meetings law. So that 10-person committee is going to have a quorum requirement of 6. So if 6 of those people meet, that's got to be a publicly noticed meeting. So if that same thing were true in your example of a 2-person committee, if that 2-person committee was created to give recommendations to the council and or make decisions that are binding, then that 2-person committee is a governing body itself, which means it's subject to the public meetings law in and of itself. It's going to have to give notice of its meetings, it's going to have to take minutes, it's going to be subject to quorum requirements, and it's going to have to be mindful not to have serial meeting violations. So just because it's not the governing body itself doesn't mean the public meetings law still doesn't apply. What a general rule of thumb is, if those committees you're talking about, if they're making recommendations to the city council or they have some type of decision-making authority themselves, it's a good rule of thumb to assume that they are subject to the public meetings law. If you're not sure if they do or not, that's a question for your city attorney just to double check and make sure that you know when you have to comply with the public meetings law and you don't.
Okay. Are work sessions merely a practice, or are they specifically something different? My understanding is that a work session is only a designation and still qualifies as a public meeting in every other policy, being a local designation by local policy.
Correct. So a work session for public meeting law purpose, so for the Oregon statute, is the same thing as your city council meeting. It's still got to be noticed. You still have to take minutes. You still got to worry about quorum, all that stuff. The distinction between a work session and your council meeting, you're correct, is a distinction made at the local level. What I would say is typically done, so what I see most cities do is they use the work session as a way to work together in a more informal setting. You don't make decisions, so if an ordinance is presented at the work session, and that's probably the best word, when it's discussed in terms of what's it going to cover, what's its impact, do people like it, do they not like it, should we be looking towards an amendment? There's no motion, there's no second, there's no vote, there's no adoption. It's literally working on the project in front of you. A lot of times you'll see work sessions when you start talking about strategic planning. It's really meant as an opportunity, when I use it in my lingo, and what I would say the vast majority of cities who are using them are, it's an opportunity to more informally work on issues coming before the council. So you're kind of getting a lot of the weighty, meaty issues kind of fleshed out. A lot of the really complicated questions are getting answered by your staff. And then at some point, what happens in the work session is either transformed into a final draft ordinance, a final draft resolution, a strategic plan. You've got an identity of what you want the contract terms to look like, and that then goes to the city council in the city council meeting for you to continue discussing and eventually making a motion, a second, and either adopting it or rejecting it. Anything you'd say different?
No, that's how I differentiate it as well too. And other times we get questions about special sessions. Same thing, it's defined on the local level. So you have your regular monthly or every 2-week council meetings that are always scheduled. Everyone knows when they're going to occur. An issue might pop up that you need to discuss sooner, and that might be called a special meeting or a work session. So it's really just a nomenclature kind of thing, but they're all still public meetings.
Okay. Considering the series meeting scenario, it seems counselors cannot really speak to each other outside a regular meeting. How, in your opinion, then, in the occasion of a citizen contacting a counselor if counselor's phone or email is posted publicly?
So I will clarify. So I encourage you to do your city's business in front of the city at your publicly noticed meeting, and that's a conservative approach. That's my advice. But I do want to remind you that the law only prohibits you from doing it from a quorum of members. So it is legally okay for one counselor to have a conversation with another counselor about city business, provided those two don't end up in a series of communications with other counselors that totals a quorum. I think because serial meetings happen inadvertently, that you run the risk of unintentionally causing a serial meeting violation when you get in the habit of talking to each other offline. That said, what's important to remember is the public meetings law and the serial meeting issue you have to be concerned about are only applicable to the governing body itself. So it doesn't apply to people who aren't members of the governing body. So it's perfectly appropriate for counselors to talk to 25 citizens about the same topic over and over again because those citizens aren't part of your governing body. It's equally true that your council can talk with your city manager, your police chief, or whomever, and not run the risk of having a serial meeting violation because the city manager isn't a part of your governing body. So that the only time the public meetings law really matters in terms of having a serial meeting is when it's the city council and the mayor. Those are the only people that are at play for that. Again, the caveat being, if you've got subcommittees, remember it would apply to those subcommittees as well. But generally speaking, you should feel free to talk to your citizens, talk to staff. That's not an instance where you have to worry about a serial meeting violation.
All right, I am not seeing any additional questions at this time.
Okay. So before we kind of finish, just to kind of touch on something with public meetings, what I always like to really recommend, and I know I stressed it a lot in the program, but if you're going to take one thing away from this particular session, it's that if your council has rules of procedure and you have not read them, I would encourage you strongly to read them. And I would encourage you strongly to take them out and review them 2 or 3 times a year. What I have found, and I think Jamie would agree with, when you have strong rules of procedure that everybody understands and agrees to, your meetings in the long run will run more efficiently. What I also suggest a lot of times is if through the year, if you notice that there's issues with those rules, like, gosh, this should be tweaked a little bit or this doesn't work, I think that's fine, make a note of it, and then maybe at the start of every year or at the end of every year, as a council review what's working with the rules, what's not working with the rules, and if you need to, make amendments to them. In my experience, what happens is we adopt the rule, and then we never really look at it again, and we start to deviate from the rule because we found a path that works a little bit better for us, and where we end up is doing something that conflicts with our rules. And it just makes more sense if this over here is really what you want to be doing instead of the rule, amend the rule so that the rules become what you're doing over here, make them match. But the first start of that process is to read them and to make sure you understand them and kind of keep them in the forefront of your mind each year. I think that's the easiest way you can make sure that your public meetings go efficiently and effectively.
So we did have one more question come in.
Sure.
What about a series of discussions with all counselors individually with the city manager?
So as long as the counselors themselves are not talking, I think that is probably okay. So remember, the city manager is not part of the governing body. So if you've got, let's say, a 7-member council, and the city councilor talks with each of those 7 counselors, or the city manager talks with each member of the council individually, doesn't share any of the information, is just communicating solely with them. That's fine because no member of the governing body has met with each other. I think that if that's what you want to do, what I would encourage you to do is have a conversation as a council with your city manager and your city attorney. And the reason I say that is because remember earlier we talked about how serial meetings are not, they're not in statute per se. Rather, it was an interpretation of the public meetings law by the courts. And in that interpretation, it came out of a case called TriMet. And when you read the TriMet decision, I personally read it as the court being really upset with kind of sidebar conversations and decisions happening behind closed doors. So I fully, as a lawyer, believe that city manager talking to each of the counselors individually is fine. I don't think that's a violation of the public meetings law because you don't have a quorum of the governing body. I do think at some point somebody may be challenged by that type of action because I think when you read TriMet, it's a sense that maybe that's not within the spirit of the law. And sometimes people will still sue when something's not within the spirit of the law, even if it meets the black letter law. So If you're going to do it, I think that's fine. I don't have a problem with that per se, but I would encourage you to sit down as a council and have a conversation with your city attorney, because each city has to weigh its risk reward, and each city is ultimately responsible for deciding its interpretation of how it wants to move forward. And I think that's a conversation to have as a city, not necessarily something for me to inherently dictate to you. Would you add anything different?
Yeah, and I think with the spirit of the law, I wouldn't abuse the ability to speak with the city manager. So I think it'd be kind of an abuse of the spirit of the law to say, for the city manager to act as like the cog to the wheel and say, hey, Counselor A, what do you think about this topic? And then go, hey, Counselor B, Counselor A thought this. What do you think? Hey, Counselor C, Counselor A, B, and C thought this. And to use them as that like go-between, I think that might be a little, I wouldn't really approve of that so much. But if it's really more of the city manager trying to say, hey, staff is trying to research this issue. What are your concerns? Okay, thank you. Okay, what are your concerns? Thank you. And not really being that conduit, I think that's kind of what Patty's saying is more acceptable.
Okay, we have a couple more come in.
Okay.
This is kind of a clarifying question. Is a quorum required for a study session, a meeting where decisions cannot be made?
Not inherently. I don't think it is. If you're not going to make a decision, you don't inherently necessarily need a quorum. And it's not uncommon, I think, to schedule work sessions and not have everybody show up. You're not making a decision. What I would always still do when I was practicing is I still publicly noticed those work sessions, and we still had, we called our city clerk, not a recorder, we still had minutes taken just as a matter of form, even if at some point we didn't get a quorum or we lost a quorum throughout, just so that we were just in the routine of trying to be as transparent as possible with what we were doing. If you think you're going to possibly have a quorum show up, you should definitely make sure that it's publicly noticed properly, because you want to err on the side of caution that you could have a quorum of your members that show up.
Okay, next question. Are there any kinds of decisions that can be completely made in executive session?
No, statute's really clear on that. Your decisions have to be made in public. It doesn't mean you can't have what I would call consensus. So I think the best example, easiest way to show this is, so let's say you're interviewing applicants for a new city manager position. Let's say you interviewed 3 finalists for your city manager position, and then you're talking about the pros and cons of each candidate. You can, as a group in that executive session, come to the conclusion that it's Jamie that we want to offer the job to. She's the person. You don't have to go into the public meeting and all of you sit there and be like, so I make a motion that we hire Jamie, and you don't even know if you're going to get a second, much less a vote. But you can't make the decision itself in executive session. That has to happen in the public meeting.
Okay, we have a couple more. A vote by council and email is not acceptable, correct?
That's correct. Like you have to, so the votes have to be in public. So I've not had it framed per se in email. I have had it for, like said, can you do it by secret ballot? And that the statute and both the Attorney General and statute are pretty clear. You have to do it in a way that it's publicly known. And remember, when you're typing your minutes, we also have to identify how people are in fact voting. So, you can't just say the vote was 5-2. I need to know which 5 voted in the affirmative and which 2 voted in the negative.
Okay, and Sherry, I see your hand raised. If you want to unmute your mic, you can ask your question.
Thank you. Can you guys hear me?
Yes, perfectly.
Okay, good. So I'm the one that's the new mayor, and so I have a lot of questions. And one of the things that I would like to solve, I think, is when we publish an agenda, or when the agenda is published, it might be like a very summary line item, and it might be something the public is very interested in speaking on. So how does it work? How should it work? What's your best advice to allow the public to say their say, but also to encourage a conversation if we need to do that? And I'll give you a specific example. We had a business that wanted to start in our little town roasting coffee, and all it said was coffee roasters. That's all the agenda item said. So when people came, they had lots of questions, and I was one of those people. So I don't know if you run into that or if you have advice for me going forward.
Sure. So I think the Attorney General gives some of the best advice, and that is that you want the agenda to give you an idea of what you're going to talk about. So if I take your coffee roasting business, if what you were talking about was a business license, if it were me and I was putting together that agenda, I would probably have the agenda item say application for business license from the coffee roasting business. For example, when you read the Attorney General's manual on public meetings, what they tell you when you're putting together an agenda is it's probably not sufficient to say approval of contracts. What they want you to say is approval of sidewalk paving contract with JK Company, something like that. So you're not giving like 20 million pieces of information, but the average person knows that essentially what you're talking about is whether or not the council is going to issue a business license to this business. Are they going to approve a contract for this? If it's Ordinance 1502, my guess is the average public has no idea what your numbering system means. So it's Ordinance 1502 and Ordinance regulating urban chicken fowl, something like that. It doesn't have to be a paragraph, but just to give you a general line item sense of what it should be. If you don't feel like your agendas currently are meeting that mark, per se, then what I would do is sit down as a council and identify what works and what doesn't work. What you'll see a lot of times, I've seen this a couple of times in rules of procedure, is they actually establish a standard agenda. So on agendas, it'll actually have specific ones. So it'll always say like the fourth thing on the agenda will always be the approval of an ordinance. And so like item 4 will be ordinance, and then they'll have like subparts A, B, and C. So it's the ordinance to approve urban chicken fowl, an ordinance to increase water rates. And then agenda item 5 is always contracts. And then, you know, A under there would be the contract with the paving company. B would be a contract with the painting company. So they almost create a formula that they follow every time, and then the little subsets are where they give you the details. The league's model rules of council procedures follows that model, where we kind of have a standard one that you follow each time, and the specifics are inherently inserted in as subsets. Anything you would say differently?
I don't know, maybe the use of a town hall. So if you know there's an issue in front of the council that's going to receive a lot of public comment, and there's just not logistically enough time to hear everybody during a routine city council meeting, I guess you could have some sort of town hall or just a session for the council to receive the opinions of the citizens.
Yeah, we've done that a couple of times in some of my city's councils. Another one is that if you have public comment, so most of the time you don't get a huge number of people turning out, but like Jamie says, if you've got an instance where, you know, where normally public comment's 5 people and you walk in and all of a sudden there's 50 people standing there, you may want to take a look, because a lot of times your rules of procedure will say public comment is 3 minutes per person, but no more than an hour. If you're staring at 50 people who want to talk to you, my guess is somewhere in your rules of procedure you have an ability to amend them on the fly and like extend that hour to say 2 hours so everybody can speak. But Jamie's right. If you've got a hot button community issue and what you really want to provide is an opportunity to speak, hear from your citizens, then maybe it's a town hall issue. You know, I would suggest that, for example, when the legalization of marijuana became an issue in Oregon, my guess is you probably had city councils who had a lot of town halls about whether or not their city should allow recreational marijuana stores in their city or not, as opposed to doing it all through city public hearings, because they probably wanted to have more of a dialogue and they knew there was going to be a lot of input.
Okay, this is the final question. During yearly reviews in regard to human resource laws and an employee's right to confidentiality, would a decision to increase wage have to be done outside executive session and open session, or can a vote for a raise be done privately?
Actually, the statute's really clear that you can't discuss compensation in executive session at all. You've got to do that publicly. So that has to happen in a public forum.
I'm going to give you one more. Someone
Okay.
followed up. What is business license? What is a business license?
So some cities in Oregon, not all, some cities require any commercial business operating within their jurisdiction to have a permit from the city. There's a couple reasons for it. I always come at it from a public safety standpoint because my husband's a former fire chief. A lot of cities require it because it allows them to monitor the type of use of the building, which has implications for how that building is classified from like a fire occupancy standpoint. That tells them how many people can be in there, whether or not there's dangerous chemicals, gives them contact information for the property owner, the business owner, in case something would go wrong. But a lot of cities have business license ordinances. Not every city does. You typically see them once you start hitting like mid to big size cities. I don't see them a lot in some of our smaller jurisdictions.
Okay, we've got a hand raised, so I'm going to go ahead and go to Rachel. Go ahead and unmute your line.
Yeah, I don't know if this is a procedure question or more of an etiquette, but we had talked about like roles staying, within, your job and then also being prepared for meetings. So I'm just wondering if you are reading your agenda packet, you have questions, you talk to the city manager, they answer your questions to the best of their ability. And when those questions get answered, you're like, this needs more discussion. This isn't ready. Would it be best to have that back and forth with the city manager or hold on to that additional discussion and questions until it was presented at the meeting?
So I think it's always best for you to have completely honest conversations with your city manager. So if they've answered your questions and either you don't have enough detail, the answers don't satisfy your concerns, or the answers are the answers and you just don't like the direction that puts you in, I think you should talk about it with your city manager. And if you can't resolve it, then it has to come back to the council. At least your city manager knows that there's still a disconnect. We're still not having a meeting of the minds, so that they can come to the council prepared to explain their reasoning, and not just that, also come to the council prepared to help you figure out what else you still need and find consensus among the council as a whole. I think the more honest you can be with city staff, the better discussion you're ultimately going to have when you go back in front of the full council. As a former staff person myself, it was super helpful for me to know that if we just weren't meeting expectations, because I think Jamie mentioned this earlier, a lot of times what your staff can do behind the scenes is if you're telling me your concerns and I'm hearing those from somebody else as well, when I walk into that council meeting, I already know that we have an issue that we have to be prepared to discuss, so I can make sure I have every available data. And maybe you've also given your city manager some time to troubleshoot. If there's a 2 or 3 day gap before that meeting, they can go back to their planning director, their fire chief, or whomever, and they can start troubleshooting some possible solutions to resolve the issue. But I think you should always be honest and forthright. You're not always going to agree. That's just the reality. But when you know that there's a disagreement or a misalignment, it will make the discussion in front of the full council, I think, more effective.
Yeah, I agree with that. And I think a lot of times it's okay to ask follow-up questions. I know sometimes I struggle with providing clear answers, and I get a lot of follow-up questions. And it is better, for the staff member or the city manager to know going into the city council meeting what kind of questions are going to be asked, because I think it's frustrating for everybody to go into a meeting and the city manager or city staff person presents something and there's a follow-up question and the city staff person has to say, okay, well, I have to get back to you. Whereas if that conversation already happened between, the councilor and the city manager could have answered that question and been prepared to answer it during the council meeting. So don't ever be afraid to ask follow-up questions.
And the only other thing I would add, and I never occurred to this on myself, my council president used to do this and I appreciated, he would regularly call staff before the meeting and ask a series of questions. And then there was always 1 or 2 times where he would say, Patty, I know you answered my question. I understand it. I agree with it. I support that position. I'm going to ask the question again in a public meeting because I think members of the public may be having these same questions at home, and I want them to hear your answers. And I think that was also super appropriate for him to do because it was his way of showing to the community that he was engaged in the process, that he could hear their concerns. But by telling me in advance he was going to do that, it also allowed me to know that I had to make sure that I had it's one thing for him to call me and me have my computer screen right there and be able to tell him the answer really quick. But if I knew that he was also going to ask it to me again in the public session, I knew that I needed to bring that data or that answers with me so I could, again, just regurgitate the information very quickly for him.
And one final quick question. Do council members have to take notes every session?
No, you're not required to take notes ever. There's nothing that says that you have to take notes. That's up to your own personal opinion. Just remember, if you do take notes, you got to worry about public records. And since this is a session on public meetings, I don't think we talked about this in public records. But remember that if you are an avid note taker and your public meetings are happening in public and maybe even on Facebook Live or on community access television, and you're somebody who's furiously taking notes, and then a week later somebody files a request for your notes and you say, I don't have any notes, it's going to look really awkward when you're on video having just been seen taking notes for the entire 2 hours. But you're not required to take them. That's your decision to make as an individual. Is that the final question for sure this time? Okay. So thank you again for joining us for public meetings. We have one session left today. It's going to be presented to you by Kirk Mylander. He's a good friend of me and Jamie's. He's the general counsel for City County Insurance. I will give you a heads up that Kirk will not be able to join us today, so we will be answering questions on his behalf. And if we can't, when we get to the live Q&A, Kirk has agreed that we can funnel those questions to him and he will answer them via email by the end of this week. So stay tuned for Kirk's presentation, and Jamie and I will see you for the last Q&A as soon as that session's finished.